who gathered here. I'm thanking you for finding the time, for your courage and boldness that you have come to us under these hard times. I'm greeting all those who joined us online. Currently, we have around 100 participants here offline, and we have more than 400 participants online from dozens of countries globally. Hence, we have not started yet, but we have one pleasant piece of news. I would like to share it with you. And I'm giving floor to Gennady Chizhikov, Gennady Chizhikov, the president of the Chamber of Commerce and Industry of Ukraine. I would like to say one important thing. Do you understand what an event should be so that the so highly positioned officials came here, and this person has a birthday. Let's greet Alexander Melnichenko, the head of Ukraine Invest, who has a birthday today. So, I would like to repeat the words of Gennady. That's our old guard, and we work. So, as said, we have quite a great audience here, and I'm certain that everybody of you will enjoy from our meeting, and you will get some information that will make it possible for you to work, to live, to implement your duties as officials. Dear friends, we work under hard conditions. It's the third year that we have war in our country. It's not the large-scale invasion. It's the real war, and we're thanking our armed forces that they make it possible for us to work here calmly. And let's thank to our armed forces and respect the honor of those deceased defenders of Ukraine and those our citizens throughout Ukraine, civilians, because the bombardments occur everywhere. Let's commemorate their memory with 1 minute of silence. Thank you. Please have your seats. I would like to repeat once more that the whole Ukrainian society lives under the conditions of war, and our arbitrations institutions as well. And the Chamber of Commerce and Industry and all the government institutions, they all work under the conditions of wartime and martial law. This is the reason why we have some novelties in the operations of our arbitration institutions. We were lucky to accommodate our activities to these challenging conditions, and I think that's about our how we perform our duties efficiently. We had a talk with Larisa Rogach, the head of the Commercial Court of Cassation within the Supreme Court of Ukraine. And we shared the idea that under the crisis and under the conditions of the current war, the court institutions are critically important, and we have such many numbers of cases that it proves that. And now we are using digital ways how to consider the cases, because it was challenging to do it in-court hearings, and now we have quite a considerable share of the cases which are considered online, and we have a proper equipment and procedures for that. We ensured our ensure that our data, which should be secured, is secured, including abroad. What about our prospects, our outlooks? If you have a look at our agenda of our readings, you may guess what the challenges are that arbitration institutions face in the Chamber of Commerce and Industry. The first is about digitalization of administering our cases. We have already digital mechanism when the parties and arbitrators communicate via email, but that's something that we already do. So it works quite well, but we need some new software that will improve our digital way how we work with these cases in order to make it more user-friendly for arbitrators and the parties. And therefore, we need some organizational material support. And I'm proud to say that USAID changed the position and on the activities of the Ukrainian Arbitration Court and adopted a positive view about our institution on International Commercial Arbitration Court, that it is could be an efficient institution to work according to the international standards. And we have some new novelties. We strive to adopt some new software types in cooperation with some international institutions in order to streamline our activities. The second thing is expanding the authorities of arbitration in Ukraine. It's about expanding democracy standards in our society, and we directly say that we want the International Commercial Arbitration Court to become a platform to resolve commercial disputes, because we hope that peace will come to our country. And we think about that investments will come to our country. And we have to ensure respective protection for these investments, and we have to prepare beforehand. That's something that we're already doing. We study practices. We have already developed procedures for investment disputes, and because the investment disputes could be also partly public issue, and there are some novelties there. Therefore, we need some new policies and laws to be developed to support this new sphere and to gather support for investment arbitration cases in future. And one more thing. If you have a look at the topics of our 11 arbitration readings, and my colleague is checking when we had our readings. So we never had breaks in holding our arbitration readings. So today we are holding our arbitration readings in commemoration of the memory of Mr. Pobirchenko, who was the founder of our arbitration practices. And It's about the strength of our arbitration institutions, which work under such hard conditions. If you have a look at the topics of the readings, of the presentations, we chose the most challenging issues. And you could see that we are going to consider the sanctions activities and how the arbitration cases can be considered under martial law regime. I think it's quite an important topic. You may look into it more deeply. The second section is on about future. It's about the investments. I would like you to pay attention to this future which will come. And let's work now together in order to greed than to meet the investments with protections. And one more thing, and if you have a look, and with due respect to my colleagues, lawyers, and attorneys, and we also engaged a lot of practitioners from the government bodies, from judicial structures, so that they will tell us about their practices. And we have here a representation of the Ministry of Justice, the Deputy Minister of Justice, and we are grateful that she has come to us in order to tell us about this extremely politicized this sanctions regime, how we should deal with it. And one more thing, and I'm going to finish with that. In contrast to the previous years, we invited some honorable guests. And you know why? If someone can analyze the practices of arbitration courts and the government bodies as regards the alternative ways to resolve disputes, this step was absolutely crucial for us. The office of the president helps us a lot in policies and practices, and that's very important. And we remember our Minister of Justice, Mr. Maluska, who officially invited 5 most renowned arbitration institutions to open their branches here in Ukraine, but they refused. We had the arbitration hearings at the Committee of the Parliament on alternative ways to resolve disputes. And the recommendations of these hearings included, for the first time within 32 years, about the national institutions to resolve such disputes. Not only the mediation structures, but there must be some government support for the development of such institutions. The third thing, we are really happy with the judiciary authorities' performance on supervision and monitoring of the arbitration court's performance. However, this year, sorry, I will tell you the truth and not only the truth. So, the commercial courts, when they had a critical view upon the alternative ways to resolve disputes, that was some sort of a competition for them. And so, you know, the theory that the court must be absolutely court's decision must be absolutely paramount. But everything is changing. And of course, I'm showing my respect to you, Larissa. And we had a meeting just a couple of weeks ago, and the joint chamber of the Cassation Commercial Court took a absolutely extremely important judgment, both for both systems. Please have a look at this recent judgment, and I think it's a benchmark decision. That's the benchmark arbitration decision about whether a party with arbitration decision, in this case, the party filed a lawsuit to deem the decision of the arbitration court to be invalid. And that was an absolutely important moment, and I had to ask you and to thank you that this decision was taken. Hence, I'm finishing with this note. I would like to give the floor to Irina Mudra, deputy head of the presidential office of Ukraine, but she told me on Wednesday that she cannot attend because she had to attend the meeting of the Commission on compensation of the damage inflicted by Russia to Ukraine. And of course, that's a very honorable cause, and obviously that the deputy head of the presidential office cannot attend. But as a responsible person, Irina Mudra recorded an audio and video address, and she asked us to show it to us. So thank you for what you did.
Dear participants and dear organizers, it's a very great pleasure for me to greet you on today's meeting, which unites the specialists and the representatives of various professions to discuss the main aspects of arbitration. Arbitration is one of the most efficient tools for the dispute resolving in business and international trade, especially when the court system is overloaded and the proceedings takes time. The arbitrage is the best alternative, and this event provides us with a great opportunity to exchange the knowledges, experience, and to find out something new. The arbitrage is caused by the development of the business environment, not only in Ukraine but also abroad. Arbitrage resolution meets the new challenges: economical, legal, and political. In Ukraine, the full-scale war has affected the arbitration as well. It made us to adjust the functioning of the International Arbitration Court to the new realities, to suggest novelties, to implement the combined procedures of the arbitrage dispute, and to implement the digital tools for the provision of the consideration of the disputes in remote. It requires not only flexibility, but also provides a unique possibility for the revision and the improvement on the existing mechanism of the resolving of the international disputes. And therefore, the Office of the President of Ukraine, during the preparation of the strategy of the court system and the constitutional courts to 2029, paid a lot of attention to the alternative ways of resolving the court disputes, and also the arbitrage courts and the international arbitrage court, which will help to provide with better access to the legislation. And today's forum will be the great opportunity for the specialists in the international arbitration for the government. So the joint efforts and the thoughts exchange will have to help to improve the alternative court disputes and improve their efficiency. I wish all of you good and fruitful work, interesting discussions, and inspiration for the further achievements in the arbitration. Let's thank Irina remotely, and let's remember her words that the Office of the President shall support the alternative ways of resolving the disputes. So thank you. And now I would like to pass the floor, and we actually hope that this speaker will join us, the chairman of Verkhovna Rada of and the head of the Committee of Legal Policy, Denis Smyslov. But unfortunately, he has a foreign trip, but he has suggested the substitution. I would like to in the equal substitution because Ivan Babi is the head of the Committee on the Implementation of the European Court resolution and alternative ways of resolution of the disputes. And he was the initiator, and he has conducted these arbitration hearings. And as far as I understand, he was also the one who was one of the co-authors of the recommendations which have impressed the arbitration and mediation communities. So I would like to pass the floor to Vitaly. To Roman Babi. Thank you very much. Thank you, Mr. Mykola, for the kind words, and I also appreciate the opportunity to join this meeting. That is a very important event for us, and it's really great to see that this event, these hearings, these readings, they are the traditional, and that is the tradition and we have the 11th readings. And even despite the difficult situation we have, and despite all of these challenges, despite COVID challenges and the full-scale war, you find the opportunities to organize these events and to manifest your thoughts, to outline the relevant topics, the directions where the institution should move towards when it comes to arbitration disputes. And indeed, we have significant challenges at the moment, and we are facing these challenges for more than 2 years. And, I was really impressed when, as far as I remember, in the end of summer or in the beginning of autumn, I received a phone call from the deputy head, Miss Inna Yemilyanova, who we have talked to her, and I was actually surprised to find out that CAS is working in these difficult times, and they are adjusting to the difficult times. And they had, as it was already mentioned, the document turnover and the online disputes. And that are the things which the traditional courts are moving towards. And you already implement these solutions. And I want to hope and I want to wish that despite all of these challenges, despite all of these difficult times, you and the Institute of Arbitration Disputes will go through these challenges and become only stronger, only more experienced and more professional. And at the same time, I would like to use the window of opportunities which we have for the institutions of the alternative dispute resolving and the arbitration dispute. So maybe there will be some difficulties. Objectively, they are there in the traditional court system. Objectively and subjective reasons, that is lack of staff, that is financial issues. But nevertheless, Despite all this negative situation, there is a window of opportunities for the institutions, so for of the alternative dispute resolving, and we have to use them, and we have to show that resolving the disputes in these institutions, in the commercial arbitration, is comfortable, is better, and is faster. And with this understanding, we have the initiative to have the committee hearings, this initiative was supported by the international commercial arbitration, the mediators, and we in spring 2024, we had the hearings and there were recommendations, and on the 31st of July 2024, the recommendations were implemented. For those of you who are interested, not only the resultative, not only the conclusions, but also the narratives, I think that there you can find the key directions of how all the institutions should move, namely arbitrage. And in my opinion, that it is important that the committee is supported, and on the hearings, all the participants supported this idea that the Cabinet of Ministers and the Ministry of Economy has to suggest in the two bilateral meetings to recommend one of the options of the disputes resolving. They can give the example of this arbitration courts. And the other thing is that the committee was suggested to establish the coordination council, in the framework of which the joint policies on the non-court dispute resolving. And as I would have mentioned, McCarthy has responded quite rapidly at these situations, and all these years passing by, and the number of the disputes resolved, it is higher than it was before the war, and that is that is the signal that they understand what is happening, that they understand what is happening, and they know what is happening. And that we can see in the researches which, in the conference papers we have today. And these people are looking in the future that Gas can become and has to become one of the centers of the investment disputes resolving centers, and the topics which are related to the sanctions, which are related to the disputes of the martial law. All of these things, which are the markers that MCAS and arbitration institutions know how to respond and are ready for these, and they are ready to adjust to difficult situations. So I wish all of you very fruitful work and, so to say, effective implementation of the ideas which we'll hear today. And as for the committee, I'm sure that our committee will do everything possible to do all the best to help with the implementation. Thank you. Mr. Roman, after these positive things, I would like to thank you once again. It's such a pleasure to thank you once again, and I recommend all of those people who are interested of the alternative ways of resolution of the disputes to read the recommendations. And once again, for the first time in the history of Ukraine, the state institution of Ukraine, and that is namely the committee, said that we should develop the national market of the arbitrage services on the basis of the national arbitrage institutions. And what you can find in these recommendations, and I would like to thank for supporting it, and тихо, громко. For the
Now I would like to present the head of the Cassation Commercial Court within the Supreme Court, Larisa Rogac. And I would like to comment. I'd like to thank you for the great document you issued on the 30th of August. I've been working in the sphere of justice for many years already, and the system of specialized commercial courts, and I have been working with them for many years, and that's one of the most qualified, most competent systems, and the previous heads of the commercial courts system of commercial courts in Ukraine made a lot in order to make it strong and in order to raise their professional level. And almost all of the judges within the system are able and are willing to resolve commercial disputes in an efficient manner.
So let me invite you to the welcoming introduction part. Thank you for these kind words. Thank you for this introduction, and greetings, dear participants, dear colleagues. First of all, I would like to thank for the invitation to participate in this event. And I would like to thank the Commercial Arbitration Court in the Chamber of Commerce of Ukraine, and I would like to say a few words regarding this. It's a pleasure for me because personally, I knew Mr. Pobirchenko, and he was my professor when I was studying in the university, and he was teaching us arbitration proceeding. And I would like to thank my teachers for the way how they increased this interest to some certain part of the court, which was a sphere I dedicated my talents and my time. My educators, my masters, taught me how to read these kind of dry, boring phrases, these tables, and to see something deeper, something more interesting, to see the detective or the novel, something really interesting. And sometimes it's a criminal story, it happens sometimes. So I cannot I would like to thank once again Igor Pobirchenko and the other my professors teachers who are here with us today. At that time, I did not perceive Mr. Pobirchenko as such a powerful person. I was just a student. I considered him just to be a great teacher, and at that time, I was not able to understand that it was a person who was the one of the people who were the co-founders of the International Commercial Arbitration Court in the Chamber of Commerce of Ukraine. And now we can understand and remember him. And the most important thing about him was his care. And it didn't matter where did he work, and sometimes even despite his age, Mr. Pobirchenko was a person who cared about his profession and his work. There is an interesting thing. If you observe the events which were happening in 2022 when the full-scale war happened, and in 2023, then you can see that lots of events were dedicated to the war crimes. So the realm we exist in, and after 2023, 2024, we started to talk about economy, about the recovery, and that is a signal that we think of the future now, about how will our Ukraine look like in the future, whether it will be working in this way? Did we form it in this way that it will become the interesting platform for the investors, so that they could work here, they could develop here the industries, resolve their disputes, and here we have no competition, because all of us have the same opinion about it. And in all of these statements, we have one task: we have to provide to ensure the rule of law and also the once again the trust to the government. And here I would like to remind you about the statement of Mr. Pobirchenko that the decision has to be fair, and that is a joint task of the national court system and the arbitration courts. So the national legislation allows us to choose the business and to choose whether it's going to be the international arbitration or that are the state court. The main thing is to provide the sufficient protection. And we are undertaking our efforts in these areas, and also the courts of the cassation courts and the national courts undertake the efforts in this area. When we're talking about justice and the rule of law, that is another aspect which is significant. We can talk about speed, but in this case, I do not want to talk about speed. I would like to talk about justice, fair decisions, so that decisions are made with the objective to restore the violated right, for people not to wait for the justice for years and years. That is also typical for both international arbitration court and also for the national courts of Ukraine. And I would like to pay attention to one thing. And the society probably lost it, or maybe that's just the challenge we have so far. And that is the specifics of this time. It's the lack of communication, the lack of the desire to find the agreement between the sides. And people are not trying to find the consensus when resolving the conflicts. And here, I remember that in 1997, I came to the arbitration court, which was obliged not only to make the decision, but also to find the consensus between the sides so that they could resolve their dispute in the peaceful way. And it's a pleasure for me that we have this kind of approach, and that mediation is being conducted during the court proceedings. So I wouldn't like to spoil this discussion with the statistics, but our courts are overloaded, and also on the Supreme Court, and therefore using this opportunity, I would like to thank the Verkhovna Rada Parliament for the attention they are paying to the enhancing the institutional capacity. And Mr. Babi, who knows our concealed idea, it's to increase enlarge our scale and to improve our e-document turnover, for us to be able to make the decision despite the fact, no matter whether there is a red alert or anything else, to have less obstacles, to be able to make the decisions on time and to make fair decisions which are based on the rule of law. And I'm sure that arbitration, the national courts are able to fulfill the relevant obligations and the rule of law. And the martial law is not the reason to decrease the standards we have, which were established in the court system. I would like to thank you for your attention, and I hope that we'll have a very fruitful work today and for the discussion of the problems we have in the system, and also to hear the opinion of the international experts. Thank you very much for your attention. Miss Larissa, thank you very much for your nice words and for everything you do in the court system which you're heading. So I have forgotten that we are working in during the martial law, and when thank you very much for mentioning that we have the bomb shelter. It's for 200 people. There is equipment there. It is fully equipped. So just in case we have air raid alert, we will probably, depending on the decision of the audience, we will stay here or we will move downstairs. Why did I mention that? Because the most comfortable and the best equipped bomb shelter. It happened thanks to Mr. Gennady Chizhikov, the president of the Chamber of Commerce of Ukraine. He spent a lot of money on it, but the safety is the most important thing. Even though we are fully independent institution, but we have, work with the Chamber of Commerce and Chamber of Ukraine. On the one hand, we are independent. On the one hand, we are working under them. So I would like to thank Mr. Gennady Chizhikov, the president of the Chamber of Commerce of Ukraine, because he is fulfilling everything that is mentioned in the International Arbitration Court, and he is helping us to operate. And this fact that all of us are here and we have comfortable conditions, that is also something we have to thank for Mr. Gennady Chizhikov and also the Chamber of Commerce of Ukraine. And when we were preparing then, the president of the CC and he went to each room for us to be able to work here efficiently today. Mr. Gennady, the floor is yours. First of all, greetings. I wish you a lot of energy, a lot of positive energy. So today we have a very important day, and I would like to thank Mykola Fedosovich and for the team, because you work in the system with a systematic approach. You work with love to those who are next to you, and with love to those who reach you out. And with lots of attention, I was listening to Miss Irina and Mr. Roman and Miss Larissa, and for us it is very important because this system works and it is efficient. It works for the benefit of our country, for the benefit of our economy, for the benefit of our investments, and so on, and that is really important. And I would like to say a few interesting and important things. We are independent, but at the same time, we support each other. As for the Chamber of Commerce of Ukraine, we are non-profitable organization, and we are non-profitable because we are working with the cases which the business cannot work with. We invest in the development of the business, of investments, and we are doing that on behalf of our Chamber of Commerce of Ukraine. One of the most important tools we have when we are talking about export, about the investments, that is when first how the courts in Ukraine work, and therefore I have spent almost 1.5 years on the meeting, which was opened by the first vice minister and prime minister. So yesterday we have opened the most powerful center of the investment attraction from Japan, which happened in Ukraine during the martial law. So they believe in Ukraine during the martial law. They want to invest, they want to work in Ukraine. And today we opened the Business Fest where we have more than 1,000 of Ukrainian businessmen, because they want to show that Ukrainian products, Ukrainian services are export-oriented, that they can be both they are 80% of our products we have on the shelves is consumed by us. It means that we learn how to work for ourselves, but without external investments, it will be very hard. So the reputation is very important. That is more money than the rest, than knowledge, than anything. The reputation is the most important thing. We are working on reputation for. So we are working on this reputation. That is the main thing, because our country will attract people and investments only when they will know that our reputation is pure. And I want to say that during these years, when I'm the president of the Chamber of Commerce of Ukraine, I'm really pleased with the fact that International Arbitration Court is moving forward, that the team is enhancing, that we have more than 60% of our arbiters that are the foreigners. And for me, as also the member of the directors of the International Chamber of Commerce, when I'm in France and when I'm meeting our bosses, they know everything about our court. They know. And sometimes they tell that very carefully, maybe you want to go to us because we know how you work great. When we're in Switzerland, they know about our court. And that means that you are doing very important work. All of you who are with us today, online and offline, you are doing lots of work for the brand made in Ukraine, resolved in Ukraine, considered in Ukraine to have the same value as we can see that something is done abroad. That is very important. That is the key message from the Chamber of Commerce of Ukraine. You work for the future. You work for the image of our country and for us to have more investments, for us to have more exports. And Ukrainian business has proved 90% of Ukrainian businesses work, they export, and they are willing to do that. But we need your joint work. And in this case, we need to join our forces. And the last thing, I would like to thank our team, our wonderful team. They started to work almost from the first days of the full-scale war. They are not afraid of innovations. They are working on digitalization. We are one of the best examples on how to work in this area, and they are not afraid of difficult cases. And that is very important. And for the business, when business is asking, can you do it a bit faster? And comparing to other countries, you are working quite fast, and that is also very important for the Ukrainian and for the foreign businesses. So thank you a lot. Good luck to you. And today's conclusions will be very important for the development of the arbitration courts, of the international arbitration courts. And we hope that on the international arbitration courts, we will also consider the investment cases together with our powerful governmental institutions, and all together we have to move forward. Thank you. Thank you, Mr. Gennady Chizhikov, and also would like to thank our honorable guests for nice, pleasant words. They are inspiring us to act better, and actually it obliges us, not only the war, but our obligation is to act as we have to act. And I would like to apologize a bit in front of the audience for delaying, for taking it too long with the welcoming word, but nevertheless, it's important to express the thoughts and to hear the thoughts of the other institutions, namely the state institutions, what they want, what they expect from the arbitration and from the alternative forms and the ways of dispute resolving. So that is our opinion, that is optimistic opinion, and it inspires us for the future. So thank you. I would like to thank our honorable guests, and now I would like to invite Ms. Inna and to start our first session of our arbitration hearings. So, greetings. We start our first session. You've seen the topic of our first session. It is called the international arbitrage and the investment attractiveness. And I'm glad to greet our colleague speakers and those of you who are with us offline and online. We have quite a lot of participants, and I was told how many of us are online. So let me introduce myself first, and then I will introduce our speakers. So my name is Inna Yemelyanova. I'm Vice President of the International Court of Arbitration Court and the Ukrainian Navy Court, and I'm going to be the moderator of this session. And now I'd like to introduce our speakers who will help us today, and they will share their opinions. First of all, I will introduce them as they mentioned in our program. First of all, we have Professor Lucas Mistelis. He is going to be online with us. Mr. Mistelis is a senior partner, the co-owner of company Clyde & Co. And the Ltd of London, and also the professor of Queen Mary University of London. Mr. Mistelis, Professor Mistelis, is a well-known specialist in the sphere of investment arbitrage, and in 2006 he was in the list of the leaders of the international arbitrage. In 2007 he is who commercial arbitration list, and in 2017 the list of global 30 leaders of international arbitration, and he is also in the raised legal confounded power list, and the list of and his legacy is great, and he is a very active, a big asset for the international arbitration, both as active acting arbitration and as a scientist. He wrote lots of books, articles, scientific articles, and we are able to see them, to read them. And then we will have Vasyl Krat. Vasyl Krat is a Supreme Court judge at the Civil Cassation Court since 2017, and before that he was lecturer. He is the PhD in legal science, and he is a co-author of more than 300 scientific articles and comments and monographies, and he has participated our events quite a lot of times. And generally speaking, Mr. Vasyl is very active. He has his own page, he has his own blog, and I think that many of the participants had the opportunity to see and to hear him during various conferences and roundtables on different topics, not only arbitration. And then Alexander Melnichenko, we have greeted him today, and I would like to greet you today, Mr. Alexander Melnichenko. I know him for many, many years, and even do not remember how many of them. Mr. Alexander, indeed, he is a famous actor. At the moment, he is the acting executive director of Ukrinvest, but for many years he was a significant Ukraine a lawyer, and he is an honored lawyer of Ukraine, and he started from the court. We remember that during the coffee break, he started as a judge in the district court, then in Kiev City court, and since 1993, almost since the independence of Ukraine, he was on the head position, the first deputy, then the deputy, and he was acting head of the anti-monopoly committee. And as far as I know, you were heading lots of groups, and under your leadership and with your participation, the anti-corruptional, anti-monopoly legislation of Ukraine was developed. And at the moment, it's a pleasure for me that you are heading this state company, which is engaging big investments to our country. And my colleague he will be in the fourth one in our panel. That is my colleague Mr. Sergei Rushko. He is the head of the Attorney Bureau, Queritas Ukraine, and he has more than 20 years of experience in arbitration. And as I already mentioned, he is my colleague. He is arbitrator of ACIC, and generally speaking, Mr. Sergei, he works on not only AICIC, but also in other arbitration courts. I'm not going to list all of them, but I will tell a few words. He is in the group of the procedures of the arbitration disputes in the framework of the association and the international community on the energy, and also he is the head of the committee of the Association of the Lawyers of Ukraine on the processual law. And beside that, Mr. Sergei Rushko is the part of the commercial court, and also he is an acting head of the Ukrainian negotiation group, and he also participated the key agreements on the enhancement of the investments, and also he is a part of, according to Legal 500 Chambers Global, and he is recommended for resolving the disputes, and he is a part of Who is Who Legal. I have presented all our speakers, and now I would like to say a few words regarding the organization of our work. We will have the opportunity to ask the questions in the end of the session. I would like to take a deep breath. For our work to be efficient, first of all, we will pass the floor to my colleagues for their presentations, and in the end, we will have the time, and you will be able or to write the questions and to pass it to me, or those of you who are online with us, you can write your questions in chance. Otherwise, in the end, we will have two mics, and when you raise your hand, you will get the mic, and you will be able to ask your question personally. So, coming back to the topic of our first session, I would like to say a few opening words. The investment attractiveness for Ukraine is absolutely not even interesting, but also painful, because our country is in war, and the damages our country suffers from, they are for our economy very difficult. And even if we look according to the evaluation of the World Bank, assessment of the World Bank, which was recently published, to recover the destroyed infrastructure in the first decades, we will need to invest around $500 billion. And of course, the state budget, considering the expenditures on the army, considering the rest of the expenditures we are facing, and the constant reconstruction of the critical infrastructure, which is constantly under attack of the Russian Federation, of course, we do not have this money in our budget. And the state is doing their best to create the sufficient legislation environment to conduct some organizational events for these investments to get to Ukraine. But of course, we do understand that why are we at the moment talking about investment attractiveness? It seems like, yes, the country is, the war isn't going in the country. What kind of investment attractiveness? And someone can say that it's an odd combination of words. It's not the time to talk about investment attractiveness. So when we look at the website of the Ministry of Economy, the war doesn't mean that all the processes stopped. When we look at the economy, then we can say that during 2023, there is information that the investments, we had around $4.25 billion investments. And besides that, we understand that the entire civilized world is discussing the matter of what one should do for the nearest, to create all the conditions for the investments to get to Ukraine so that these investments to be observed by the state for the sufficient mechanisms of the investors' protections to be there. So we don't understand investors, except with the investor is considering not only the investment perspectives, but also the legal aspects. What will happen if something goes wrong? An economic factor is also very important, but when we're talking about the protection of your own capital, of protecting your own investment, it's very important, and that is a broad range of questions. And we are going to talk about, first of all, about the arbitration as the important part of the investment protection, but also we are going to talk about the protection in the national courts and the change in the legislations which happened recently, so that we could create the legal environment. So what are the questions we have so far? And what are we going to consider during this session? So what should we do in case we have arbitration investment dispute? What should we rely on? Arbitrate institution, and there is a very nice saying that arbitrage is as effective is its arbiter. Or otherwise it is said that the quality of arbitrage cannot reach the higher level than an arbiter have. We are going to talk about the stability of arbitration clauses. What kind of legal protection do we have in Ukraine, and also what is really important, even though it is the question is lost in our panel, but nevertheless, the question of the future of our state from the point of view of the investment disputes, and that is whether Ukraine will become the place of the arbitration, and what do we need to do for that. And I would like to invite for the word Mr. Professor Lucas Mistelis with his presentation, Arbitration Institution or Recognized Arbiters, Selection Criteria, Investment Disputes. He is going to join us online, and I hope that he is online with us, even though we are a bit late. Mr. Lucas, I'm very sorry that you had to wait. Unfortunately, we were a bit too long with the introduction. Please, the floor is yours.
We cannot hear you. There is no sound.
We cannot hear you. We lost the picture and the sound. I guess we have some technical issues. So in case our speaker has some technical issues, I think we can move forward until we resolve the technical issue. So, Mr. Vasil, even though we did not agree that, just a few... Yes, we can hear you. Yes, we can hear you. Please, the floor is yours.
I'm not sure whether. Okay, so now I'm given the green light that I can start. So thank you very much. So I'm delighted to be joining you, albeit remotely, and to address a very important topic. The introductory speeches, and indeed Ina's introduction, highlighted very critically the importance of investment for Ukraine and the importance perhaps to situate a lot of this investment disputes within against other parties. At the same time, we experience a rather critical approach towards investment arbitration altogether. Some of this approach critique is directed at arbitral institutions. Some of this critique is directed against arbitrators, and some of these disputes are directed against the institution of investment arbitration altogether. So I've been asked to identify one particular issue, and that is the question of the criteria for the selection of arbitrators in investment disputes, and whether it would be better to have an institution selecting the arbitrators, or whether we can go directly against arbitrators and select the appropriate arbitrators in this context. So I will split my 15 minutes about in three main topics. Of course, the objective, and that's where I come back to the end, is to identify the best possible arbitrators for this particular dispute. And there are two questions, and I will offer my conclusions in the third part. The first question is, do institutions know best? Is that a true statement or is not? Or is a market driven approach of approaching directly recognized arbitrators the better option? Can we identify on the basis of past experience? We have officially about 1,300 investment disputes known on the record. Can we define what are the key characteristics that we would like an arbitrator to have? So I will start with the first questions. Do arbitral institutions know best? There's a historical debate, partly academic but partly practical, as to whether we should trust institutions to appoint all arbitrators and therefore move away from the model that every party appoints one arbitrator and the two party appointed arbitrators, with or without consultation with the parties, appoint the third one. Let me first make a small historical statement here. There's quite a bit of empirical evidence that up to the end of the 19th century, up to about sort of the beginning of the 1910s, the beginning of the 20th century, most arbitration disputes were resolved by a sole arbitrator. The idea of a three-party tribunals became more prevalent from 1919. Johnny Vida, the late Johnny Vida, records in a historical article he has written about a number of nationalizations that the Soviet Union did in relation of resources that were either UK or American resources. And he documents how Lenin and Lloyd George entered into a negotiation about the appointment of arbitrators, and so that the arbitration can go ahead, in an article which he sort of jokingly called the Lenin, Lloyd George, and the Cannibals. And out of that sort of negotiation, we come to the model that every party appoints one arbitrator and the two party appointed arbitrators jointly appoint the chair. So institutions have different models of appointing arbitrators. Some institutions have a closed roster. They have their own list of arbitrators, and they will only appoint arbitrators from within that list. That is a rather old-fashioned and quite protectionist model, but is a model you see in a number of Asian institutions, a lot of some Eastern European institutions, and some South Asian institutions. The more widely sort of accepted model these days is to have a recommended roster. An institution has an indicative list of arbitrators, but parties can nominate, and appointments of arbitrators can happen even outside that list. That's a sort of a good compromise. The institution offers the parties the opportunity to choose from a list of arbitrators, even if they haven't thought of any arbitrators or they have no experience, but that list is not closed. And to some extent, that's also the method we see within ICSID. Every member state that has signed and ratified the ICSID convention has the right to nominate a number of arbitrators for a period of up to 6 years, which is a renewable period. But ICSID could appoint arbitrators also outside that list. And ICSID in some cases will also itself could go outside that list. Then we have a system which is quite supposed to be the more modern way, where an institution will have no roster. That's, for example, the system in the International Chamber of Commerce. The parties can nominate arbitrators and the institution will appoint them, but there's no roster. So there's entirely freedom in how to do that. And of course, we have some arbitrators where the parties directly appoint and the institution merely confirms, does not involve that appointment process. And of course, we have institutions which do not nominate or appoint directly, but they instruct an appointing authority so that the appointing authority can do the nomination. This is happening in some cases where the PCA, for example, the Permanent Court of Arbitration, appoints arbitrators on behalf of the parties, and the PCA itself doesn't want to make that appointment itself, either because the arbitrator, the understanding is that the arbitrator will come from a jurisdiction where they may not have enough local knowledge, and they will appoint the local appointing authority. So, do arbitration institutions know best? Jan Paulson often argued, especially after he stepped down as being president of the LCIA court, that institutions have a very good overview of arbitrators. They are dispassionate. They don't have any favoritism. They don't have to appoint friends of the president of the court or of the institution. And the parties' process sometimes is too much based on who they like, and that sort of creates a bit of a tension in the tribunal, in the sense that every party will appoint a reasonably favorable arbitrator. So, but I think we have not accepted that model. We have a system where parties and institutions have role in the appointment. So let's assess what do institutions know. If you talk to people within the ICC Secretariat, they would argue that the ICC knows very well whether an arbitrator is efficient, because they have data as to how quick an award has been rendered after the proceedings were closed. But is that a good indication? What if we have a 3-member tribunal, and can we attribute inefficiencies to the chair? How we can attribute inefficiencies to a party-appointed arbitrator who is becoming disruptive in the deliberation process or doesn't participate in the deliberation process? Yes, efficiency is a number. We know how many days or how many weeks or how many months it has taken for this particular tribunal to produce an award. But appearances can be deceptive. We do not know the dynamics. Of course, institutions also have a good understanding of the approach of arbitrators towards ethics and disclosures they make. And the duty to disclose exists in all arbitration rules, but how this is exercised differs substantially depending on the jurisdiction where the people practice. I have been in arbitrations where I would make a lot of disclosures, having been appointed by a former student or a student of 10 or 20 years ago. And the other party-appointed arbitrator had made no disclosure, and it's very clear from the process, from the coffee breaks, that that arbitrator is very, very close to the party that appointed. Sometimes they even travel to the hearing together, and no disclosure has happened. So again, that is typically something that institutions know, and actually institutions know more than lawyers in these cases. But institutions only rely on their own data. They don't have data of other institutions, and the data set is limited. So what institutions do not know, and in many cases they don't have no way of knowing, is if the tribunal is deemed inefficient, we do not know what the causes of inefficiency are. And they might ask questions, but most likely that would not sort of generate the information. Also, institutions do not always understand tribunal dynamics. It might well be the case that a member of the tribunal has communicated with the case manager in charge of the case and sort of vented some concerns and perhaps some issues about the deliberation or the attitude of arbitrators. But that's one side of the story. There are three arbitrators and the dynamics affect all three. And can one rely on sort of one person complaining? Is that the right approach? And of course, institutions cannot really fully assess whether contributions, negative or positive, are attributed to one or the other party. Now, with institutions which have closed list or nearly closed list, there's a lot of critique that sometimes there's favoritism. The institutions become old-fashioned. The person in charge of the institution likes to appoint people that they know best. Is not favoritism as such, because institutions normally appoint whoever they think would be the best person for the case. But that's often for somebody who's very close to the institutional management. And institutions also have their own agenda. They look at questions like, for example, diversity, how many new arbitrators they appoint, whether they appoint sort of how many women they appoint, sort of different other constituencies, law firms, sort of judges, ex-judges, and so on. And of course, institutions are almost obsessed, I would argue, with reports and statistics, because that's what a quantifiable assessment of the institutional work. The alternative, of course, to relying on the institution is that parties make direct appointments and they recognized arbitrators for their profile, and we acknowledge that the parties can directly appoint arbitrators. We have these days a lot of sources of information. I'm just mentioning three here. Global Arbitration Review has something which they call an arbitration research tool. It's not entirely up to date. For example, my own entry has not been updated for 4 or 5 years, perhaps even more. But it has a questionnaire that an arbitrator has to appoint. And then the arbitrator discloses cases that they have worked and the arbitrators they have worked with. So you can see a bit of sort of the profile of the arbitrator and how the arbitrator has worked on the type of cases, the law firms that appeared in before them, and so on. It's a service that has a subscription, so it's not accessible to everyone, and is a service where a lot of the data is provided by arbitrators themselves, but they're verified through sort of a number of questions that GAR asked all the related parties. Then we have in investment arbitration, the list of arbitrators that is maintained by Investment Arbitration Reporter. That's again a subscription service, but it's not an additional subscription to the basic subscription. And then you have information of the type: who appointed the arbitrator? Is that a claimant or a respondent? Is that the chair? Is that appointed by the appointing authority? And you see the number of cases, and then links to the articles that relate to the arbitrations where the arbitrator was involved, and so they get a bit of insight. Mundi, which is another subscription service, also has a conflicts checker. You can see the profile of the arbitrator in relation to other arbitrators you might want to appoint in this case. Have they sat together? Are they linked together to a firm? So it's very much about a sort of 6 degrees of separation, trying to create this network and understand the conflicts. There are other services, of course, Legal 500, sort of chambers, We have who is who, lexology, etc. There was also a service which was heralded as the game changer in the picture. What that was called arbitrator intelligence. This is a process that in the end failed. It was a startup and remained a startup for reasons that we're not going to discuss now. But if you look at arbitrators and in the beginning sort of describe that I'm listed here, I'm listed there, there's a lot of ranking of arbitrators. But everyone who's been involved in ranking of law firms, of institutions, they know that we have to take them with a pinch of salt. Can we always trust numbers? Do an arbitrator gets better ranking because they're prepared to talk more about their cases than somebody else? So do arbitrators who observe confidentiality fully get a worse press or don't get enough press? I know people that they will call GAR as soon as they have rendered an award. I've never called any institution a journalist or otherwise about a case I'm involved. So what do numbers and ranking reveal? Of course, they reveal that people are popular, that they are on demand, but they do not necessarily say much about how they run the cases. And of course, the rankings, now we have, of course, future partners, new generation, future leaders, but they could possibly create an issue with diversity because you see the people who are on the upper end are the slightly older and more popular, and that could be a bit of an issue going forward. In my personal experience, it's a matter of professional duty to interview arbitrators you do not know and arbitrators you want to consider in major cases. When I act not as an arbitrator but as a counsel, I will always make a case that we have a short list of likely arbitrators and will interview them. Of course, the interview is very limited. We don't want to compromise the arbitrator. We'll ask about their experience, availability, and conflicts. And there might be a couple of subtle questions that one can ask, but without breaking sort of the rules of ethics that are relevant. When I'm being interviewed, I will always make a point of making a good record of the, not an official recording of the interview, but I will do a record and I will be prepared to reveal it to the other parties and to the institution if I'm appointed in this case, because it's appropriate for that disclosure to be made as necessary. So when then we looked at recognized arbitrators, what makes them recognized? Sometimes the fact that they are speaking at conferences. So there's market, of course, has a role, and market recognition is significant. But we also see that certain recognized arbitrators have certain profile. A lot of the highest sort of recognized arbitrators come from Western Europe and North America. In that respect, Western Europe, interestingly enough, would cover Australia and New Zealand. We see that arbitrators have become much more profiled in the last 4 or 5 years because there's a drive to promote arbitrators from Africa and the Middle East. But again, we don't see hundreds of these names. We see perhaps 5 names or 6 names that we see very regularly. So neutral nationalities, market forces are having a substantial role in that respect. So then let me turn to my final point. What are then the key desired selection criteria? And then I will reply to the question it was said to me, is it better for institutions or for parties to directly appoint? So what we expect from an arbitrator, we want competence and we want expertise. Competence is often a very technical skill. We want an arbitrator to be able to manage the arbitration effectively. We want an arbitrator who, when a request comes from one party, doesn't automatically, for the sake of an efficiency, give an answer, but invite the other party to give the review. But that invitation comes with a time limitation. We want somebody who's open-minded in several aspects, like security for costs, interim relief applications. So somebody who is open-minded, has experience and knows how to run a process, and has the necessary skills and support for that. Of course, we also want substantive expertise if the dispute is about, for our purposes, let's say gas pricing or the revocation of a license. Of course, in relation to Ukraine, there's now a number of cases that relate to destruction of infrastructure and investments which are privately owned by Russian troops. We want somebody who has that technical expertise, but also the public international expertise to understand how these matters would work. So we need subject matter, legal subject matter, but also geographical expertise. And ultimately, we want somebody who understands also international law, how attribution works, how causation and damages work. So in the technical expertise, we also refer to it as efficiency. That's a case management style. The predominant popular style in arbitration is what I often call as a Swiss style, where you hear both parties, is more about making sure that the parties have had a chance to say what they're going to say. And the award actually records extensively these submissions. And the role of the tribunal is to sort of navigate between the two submissions and to give it the tribunal's views. Perhaps, and that's a criticism to that style, this continental European style, is that you spend more time summarizing the position of the parties, and when it comes to the tribunal's own contribution, that sometimes is a bit too short, only 4 or 5 paragraphs. While if you have a more English style or American style arbitrator, it's less about summarizing every argument that has been made and more about the discussion and how we came to that conclusion. Now, in terms of efficiency, of course, many efficient arbitrators either use a tribunal secretary or they have a backroom. They have an associate or sometimes senior associate or even a partner in their law firm, which assists with the management of the process and the drafting of the award. But ultimately, we want an arbitrator who does not sit on the fence. We want an arbitrator who is prepared to make a decision and is prepared to reason on that decision. We also want an arbitrator who is available. In one of my recent cases, one of the arbitrators appointed by the other side disclosed that he's involved at the time in 53 cases. If I were an arbitral institution, I would not confirm that arbitrator, because either this arbitrator would not do any meaningful amount of work, or the work would be very sloppy, because how can meaningfully one sort of jungle between 53 cases? Even if your role is as a tribunal as a party appointed arbitrator, still you have to give each case a level of attention. So availability is important. That's an argument to promote younger arbitrators and focus on diversity. The final important selection criterion for my view, and is often overlooked, is psychology. We want somebody who has the right interpersonal skills, especially when you choose a party appointed arbitrator. You want somebody who is mild in their attitude, communicates very well with the chair, communicates very well with the other arbitrator, communicates very well with the opposing counsel. We don't want somebody who has a bit of the temperament of, lack of a better word, or a better example, Donald Trump, who is very obnoxious, or talks over other people. So you want somebody who becomes part of a team that will make a decision. We often overlook these interpersonal skills, and people want to appoint somebody who appears to be a very strong arbitrator, but very often this strong arbitrator would be alienated by the rest of the tribunal. So who knows best? I know that we are speaking in the context of the readings which are organized by ICAC, which is an arbitration institution. And I think there's really no doubt that institutions have quite a bit of knowledge, and it's knowledge that is not commonly shared. But in my view, we need a dialogue between the parties and the institution. I think the institution, if they're minded to make an appointment, they need to engage with the parties. We need to ask the parties about the criteria they want to do to the arbitrator to have, particular skills and knowledge, and therefore they should be prepared to go outside the roster. So that collaboration engages the parties, engages the institution, and ultimately increases the legitimacy of the whole arbitration process. And I think without further ado, I will be stopping now, and I think that just talked a bit over my allocated time. Thank you.
Thank you, Mr. Mastelli, and I hope you will find this opportunity to stay till the end of this panel, because in the end we will leave a bit of time for the Q&A session. I really appreciate your that is a very interesting topic, how we choose the arbiters. It's a very important question for the efficient of the arbitration proceedings, and whether it's the normal dispute or not, the results depend on the arbitrate. And the next presentation from Vasil Krat, and we are going to talk about the stability of the arbitration clauses in terms of investment attractiveness. When we were opening this session, I would like to repeat that it was called the epic question, that arbitration clauses cannot be the topic of the separate lawsuit, so that we won't have the situation, so that it wouldn't appear that the party makes the diversions and applies to the international courts to consider the clause null in void. And I think that Mr. Vasil will tell us how will it affect on the arbitrational attractiveness. Greetings, colleagues. I'm very glad to see all of you. We haven't seen for quite a while, and meeting you offline is not like meeting you online. First of all, when we discuss the topic, Mr. Chirikov has said very interesting words, that reputation is more than knowledge. Oh no, because not the national court cannot be incompetent, and the arbitration court cannot be incompetent. So Mr. Lucas says, and we in some way hyperbolizing the terms and time. And I was listening very carefully to Mr. Lucas, and it's really great that it's the tricky way. There should be some common sense in all of these, and the expertise and the knowledge should be there, and also timely manner, but in the framework of the common sense, because the person physically cannot do more. So we have to understand that timely manner in some cases leads to not covering something from the point of view of knowledge. So we cannot say that reputation is more important than knowledge, because in this case we interpret that what is actually reputation in this case. So can arbiter or the judge be the reputationally clean one, but for example not to know about the over contract with or any other Latin wording. So it is reputational. Well, at some point when we are talking about these kind of things, so for me it is something very interesting. The reputation is more important than knowledge. Oh no, that's too much. Reputation consists of knowledge, of timely manner, of efficiency, but without further hyperbolization. So when we are saying that there should be some kind of Ukrainian product, arbiter or reputation, so the common says, okay, the knowledge, fine. So can you imagine anything without them? You cannot move further without them. So that is just off topic. Sorry. Okay. Sorry. I started to talk about the loans, but it's like. So, with Mr. Sergei, we were organizing the event on the draft law, and we were discussing. So, I do not know the arbitrational legislation. So it sounds really nice. We have a nice word, cool. I was saying it both here and here, on those events and here. So in the context, so I think I will structurize my speech in a non-typical way, because we paid a lot of attention to the cassation court. So I'm going to talk about the historical cut and about the relevance cut. So speaking of the historical cut, it seems like paradoxical, but in 2018, I guess on the 20th or on the 12th, I guess I cannot see Mr. Taras. At that time, he had an event dedicated to arbitration courts, and we were talking about arbitration clauses. So what is it? And at that time, I paid attention to the fact that we have to talk about the preceding agreement that can be a part of the agreement, and a part of what? About the private commercial agreement. And at that point, I said that we have to split material aspect of these voidness and processual aspect, because they are changing and they are absolutely different in their concept. In the future, and how it was developing further, cassation and in the many decrees, so which were established and issued in 2018, which were announced right here, it was implemented in separate decrees. So you can see that on the Article 67 of the Commercial Code of Ukraine, there are the decrees of the Cassation Civil Court, which are issued as the civil court, so there is a double function of the court, and I'm still not got used to this double function. It's a bit different. They work as appeal, and in the many decrees, they were saying that as the fact in the context of the arbitration clause starting from 2023. Meaning that the time framework in the historical period, it seems to be not very significant, 2018 December and 2023, 5 years. And the level of how qualification of this construction is happening is significantly changing. And generally speaking, now we are talking about the fact that this statement that it's a processual clause, it gets approval from the side of the chamber. So this is historical cut, and everything was happening in this hall. So yes, indeed, maybe today we will have something, and Mr. Mykola gives us a hint that maybe something will be here happening again. And as for the concept, so the civil turnover like silence, and of course, I mean, not literally. So the agreements are not signed not to be fulfilled, and not for being considered invalid, and to consider them null and void. And this silence, it concerns any kind of construction the parties agree on. They agree that it has to be fulfilled further, and not to destroy everything, not to follow it, and to say, no, we are not going to act in this way, let's think otherwise. So this silent, what does it mean? So whether we want it or not, but there is invalidity, good and bad. So that is when we're talking about good invalidity. For example, the lawsuit which is against the institution which is providing with the laws, and of course these, and we also have the negative invalidity. Why it can be bad? Because mostly the parties, how do they want to use all of these opportunities? Not to fulfill their obligations. For example, as in our situation with the arbitration clause, for it not to provide any kind of petition expertise to the arbitration court. At some point, we will look at any kind of invalidity. There is a good one and there is a bad one. So on which side, what kind of sword will you choose? Anyways, to provide this kind of stability, we need to have no bad invalidity. So it should not work in this way. Sooner or later, we will start talking about it. In the context of any kind of construction, yes, indeed, it started paradoxically with the arbitration clause. In its framework, we started to say that this invalidity it's happening on some certain stages, not when we got everything, not when we started to implement everything, but only those stages. And that's it. And that's the end. To ensure the security is impossible in the other ways. And how stable it is going to be? What are the frameworks? And of course, we can say that, yes, indeed, there is Article 203, which will allow to do that. But there is another perspective on this matter, because the historical cut, the historical introduction in the context of splitting the material and the proceedings part. And when we are talking about the things which are the part of the, which are according to Article 1, Clause 1, so the subject of the commercial proceedings, or maybe in the private, in the civil court, there can be the clauses on the processual law when it comes to eviction of the people. Yes, this standard is there, but nevertheless, we have to understand that the law on the arbitration court on arbitration, they are specific, and these specifics is in both terminology and the terms of references, which are not typical for the court. That is a procedural cut, which allows us to say that this component, this arbitrational agreement, is subject to subjective area of invalidity, and the importance of this decree of the joint chamber of the cassation court says that it's not the subject to the qualification of the material invalidity. And yes, we got used to the fact that any kind of agreement we can try to consider it invalid, and or the legislator can say that it can be considered void, or through the other systems, so we can do that. Should it be in this way, from the point of view of procedural agreement and arbitrational clause? Obviously not. And here, I would like to make a statement that the civil agreements like silence, it means that there should be no means to nivellate these arbitration clause. So the mechanisms move to cancelling the decisions and to the permit to implement this clause. And of course, I'm quite confident that we are just in the beginning of this way, and there will be both critical approaches and the other approaches. And in my opinion, the biggest task we have so far is to preserve and at some point to enhance the argumentation and why this option was selected. This kind of stability, it's what does it allow us? It helps us, both arbitration and the court, to consider the case, and it makes the working load on the national courts lower, even though, well, it is so to say decreasing, because after that the parties are trying to undertake all the possible efforts for these resolution not to be implemented. So it's 50-50 situation. So here we have two important blocks, historical and material. And if there are questions, I guess they are going to be in the end. So I guess they're definitely going to be the questions. And Mr. Mykola, for you, an exclusive right to ask the question. So you remembered my age, okay? So I do not think that it's that we should say that we were started to consider arbitration agreement at the procedural proceeding and the cassation civil court. That is our fault that we did not mention it, and I'm nivelated for the first about the arbitrage position, pro-arbitrage position was made after the new edition of the arbitration courts, and who were in charge of the civil arbitration, the civil cassation court. And please tell to Mr. Boris my honors, my respect. But we were talking, we were saying, so he was the one who looked at the arbitration agreement on the procedural documents. That's not true. The most important thing is not this. The most important thing is about a bit different things. So we were saying that it's good because cassation court said that the appeal cannot be appealed to the commercial court of Ukraine when it is considered, when the agreement was considered to be invalid by the arbitrage court. That is the most important. And the two cases, and they were quoting the law on the arbitration courts and the law on arbitration, it explains only when it is arbitration this resolution is cancelled or when it is fulfilled. So once again, the commercial courts which were considering the separate a few appeals, it was not undermining the reputation, but it was making the international arbitration, they made it a bit nervous. So we were leaving it. But now we have the grounds. And speaking of the procedural nature of the arbitration clause, so that is the subject to discussion. Why, for example, the cassation commercial court of Ukraine returned to this concept to enhance, even though they have enough justification, because the separate appeal on considering the arbitration resolution invalid is impossible. And the fact that you were the first one and that you did more for the arbitrage, more than anyone, than the civil courts, and that your expertise, that is your expertise, and well done. So pass it to your colleagues, and I'm passing the floor to you. Thank you very much. The question, as far as I understood in the end, okay, because we're out of time and we also have the other panels, and Mr. Volodymyr is looking at me because he's the moderator of the second panel. And in the end, I would like to add a bit on the arbitrage, but during the question. So I would like to pass the floor to Mr. Alexander. Please turn on your presentation. And Mr. Alexander, he is going to tell us about the component of the from the investment attractiveness from the point of legal protection and support of significant investments in Ukraine. And also he is going to talk about the guarantees and the protection of these investments. Thank you. Thank you, honorable guest. It's a pleasure for me and a great honor to be around among you. And even though we have the people who know everything about me during many years, I will tell just a few words that yes, indeed, I had a very very big changes when I was a part of the court, and the head of the chamber, he was inviting me. But at that point, I have chosen the anti-monopoly because I was interested in the opportunity to combine economics and law, and to be the part of the I call it not the anti-monopoly, but competition legislation. And unfortunately, at the moment, we are still using the Russian terminology. And indeed, there are people here, like Mr. Mykola and Mr. Natalia, Mr. Alexei, who know me for many years, and they were supporting me. And Mr. Igor, Pobirchenko, he is my teacher. And the last meeting we had on the Yalta conference, which was held in Yalta Interests in 2008, when we were discussing on the legal hearings, and we were confronting the Russians, who were also the part of this conference. So I'm very glad that I'm able to present my position in the other role. And yes, indeed, at the moment, I'm the acting head of Ukraine Investment. That is a legal office, which is in charge of two key things, according to the legislation, on the investment protection. I'm very sorry for making the names shorter. In fact, you can find all this information on our website, and you will be able to find all of this information there. You can scan it, and you can get all of this information. And by the way, we developed the guidelines, and now I approved the new version of the significant investment, and we have already uploaded it, and I hope we managed to do that. And we have materials both in English and Ukrainian, and you can use the terminology which is mentioned there, and there you can find all the legislative framework for us to understand what are we talking about right now. I will try to open the next slide. The governmental office is working since 2018, but recently, by the decree of the government, we have the support of the significant investments, because indeed we can work with the other types of investments. But the thing is that we have a small staff. We are not like Jeffra. We signed the agreement with yesterday. That is an agency on the external trade of Japan. And yesterday there was a Prime Minister of Ukraine, Denis Shmyhal. The first was Prime Minister Viktor Sverdenko, and we have signed this document on cooperation. And in their office, they have offices in 76 countries. That is a huge agency which is in charge not only of the supporting of investors, but also collecting the information which is provided to Japanese government and Japanese businesses, the business organizations, and that is the topic for a very important discussion, but that's not the topic of today's discussion. So the Minister of Economy, as executive authority, has the key role in both as investment policy, and Ukraine Invest is the state organization, the governmental organization. You know, we can say that it's that are the eyes of the government on what is happening, and the attempt of the government to have some other view on what is happening in the investment implementation, not only in the investment policy. And we are trying to fulfill this obligation, and the huge work which was conducted and the previous team supported us, and now we have a solid team, and this team, as I said, they are supporting huge investments. So what does it mean, huge investment? I will try to briefly explain it to you. I'm not going to take a lot of your time. That is an investor who is investing in the economy of Ukraine, 12 million euro plus without VAT, plus 12 working places. So that is a primitive explanation of this scheme for you to understand it better. And then what happens? So investors to reach our market, they have to believe that in Ukraine there is the economic investment environment, investment institutions, and that is a role of Ukraine Invest. That is a small team, and I so call the investment managers, which is supporting investors to prepare the application, be justification. So I'm not going. So while we are talking, our small team is working on the next technical justification, and we can say that it's not a secret anymore. This company doesn't care about about this FinSpam. They announced about their investment quite a long time ago, but and their process is not very active due to the fact that, despite the fact that they are supported by a famous company, I'm not going to name the name, but they are very well known. And at the moment, for the second week, we are preparing the technical justifications for 2 weeks. Our team works, in fact, only on this. There were so many mistakes and unclarities which will not allow to work with the Minister of Economy, because the way of the path of these documents. So you understand that there is the documents about the financial capacity and so on. That is a topic for a long discussion. By the way, we are ready to conduct these kind of discussions with legal businesses, with potential parties, because we prepared the methodological recommendations, and that is quite a solid document on how should the technical economical justification be done, and what are the mistakes made by the investors. And therefore we are preparing these kind of documents, and maybe it's not correct to say in this way, but I can say that on the 4th of October 2024, recently, the government of Ukraine has approved the first investment project and prepared the documents to conclude the special investment agreement. On the grounds of all of this work, the application is sent to the offer is sent to the Minister of Economy, and I will tell honestly that not without our support, because we are consulting the Minister of Economy, and after that, the government decides that this agreement can be concluded between the government and the investors. So Ukraine undertakes the obligation that in case these agreements will be fulfilled, 30% of the investment in this or the other way will be returned to the investor. And in this way, it is very profitable. If 12 million investments and 3.6 million is returned to the investor, that is great. And at this moment, the thing is that there are 2 agreements, and right now I'm just torn apart, because 2 to 3 p.m. Anatoly Sverdenko is signing on Mostetsky Arsenal is going to sign this first special investment agreements. And greetings, congratulations to all of us and me. Why? Because it removes this veil of uncertainty, this mist of uncertainty on the topic of the significant investments and Ukraine, the war. And whose jurisdiction is that? Jurisdictions of the dispute resolving, it can be chosen by the investor. Please, you as investors, so with all my respect, when you are an investor, you have all the doors open in front of you. So we are saying that at the moment, Ukraine has already created the model, which is already working. So today, no one will say that it's not very clear that Ukraine Invest is doing something clear. And what does Ministry of Economy do? So they had the team. We have to be very direct. The team of the President of Ukraine, they created this model of the significant investments, and it started working. So what else do we have? What Ukraine Invest is going to do? These two agreements are going to be signed, and Ukraine Invest will be supporting the implementation of this agreement up to the very end. According to the law, it can be up to 5 years, and therefore we are going to be the eyes of the government. We are going to be the eyes of the government on how this system works in the future. We are not sitting and doing nothing. Besides the fact that we are doing this work and support the investor, and here you will see, you will open our website and even right now, and you will see what kind of preferences and subsidies does the investor have when making significant investments, also during the implementation. So a few things mentioned there. I do not want to take your time. And by the way, this slide about 30% capex and about the preferences and preferences for investor. And of course, there are some certain spheres mentioned here of the implementation of the investment projects, because it's not all types of energy, it's gas and biomethane, but practically all the life of the society, all the economy is presented here, and that's very important in our project. And we are at the moment in the process of negotiation with the members of the parliament. What do we consider to be worth adding to this list of the spheres of implementation? I'm not going to name that because the decision was not made, and I would like to keep it a kind of conspirology secret, but nevertheless, I would like to emphasize that the investors we have, by the way, after due to signing these agreements, many investors believe that Ukraine has the investment capacity, and the fact that in 2024 in the budget we have 3 billion hryvnias for capex. This year, it will not work out. I will be absolutely honest with you. The state will not be able to do that. They will not be able to get this reimbursement. And sometimes I'm saying, like, look, in 2025, there is nothing at all. So far, yes, but we are working on it. And I think that considering that the first investment agreements are on their way and they are operating, and the moment they are start being valid, and except for the legal framework, the institutional framework exists and it is real. And we have MINEK, we have Ukraine Invest, we have the Cabinet of Ministers, and we can say that the investment policies, the investment law enforcement is possible even during the martial law. And the martial law in the war is not an obstacle. And yesterday, by the way, I was mentioning that we have signed the document, and in my opinion, that is the first most important document from JETRA's initiative, the Japanese Agency on the External Trade. There was a memorandum with Ukraine Invest, and it is a pleasure for me that we work with them for 1 year. He was just starting this work, and they are the ones who decided that they want to work in Ukraine with Ukraine Invest. They believed in us, and I can assure you that we will implement this, that we will fulfill this trust, as well as when I was had obligations toward the Cabinet of Ministers, and when I was coming here, I said that we will implement this project, because I do not want to name the surnames of some famous people who were asking me, do you have adequate people, that is literally, who can manage invest project? Yes, I said we do, and we will do it. And another thing I would like to draw attention to, dear participants of our discussion, we have identified and on the website the steps for the investors, 7 steps you have to undertake, and in fact I have named them, and I'm not going to stop on this because this topic is worth 1 hour, the roadmap of the preparation. And for the investors, if you're interested, you will be able to find it. If there are any questions, you can ask these questions later, and after that we are ready for the discussion. We are ready for the moreover, we would like to have these kind of discussions. We plan that we will have these discussions. For the legal companies who are working with investment support, we will organize a separate online seminars and the conferences. If you want in English, if you want in Ukrainian, and that is for different audiences.
So, and by the way, I would like to express my special thanks to those who are here. You know, it's Friday, it's afternoon, but you can find this information on our website. I would like to thank all those ministries and government agencies who support us, and you may have a look at our website, who does quite a lot of work. And now we're speaking about the signing the special investment agreement. And one more thing that I would like to say, I would like to thank Ina and to the Chamber of Commerce and Industry. I would like to take about to Mykola Selivon. So we are in the same boat here, and that boat is called Ukraine. I don't like all these high words, but I have to say that the things that you do, the Chamber of Commerce does, all those things that you do, these are for long-term goals, for achieving long-term goals. We're creating the foundation now that we're going to use afterwards. And now, during the war, we're already building the foundations for further understanding of the foreign investors that Ukraine can provide support for all those foreign investors, analytical support and assistance, and we do it free of charge. So thank you for your attention, and I will be happy to answer any questions, and thank you for the invitation. I have a question to you, but maybe I will ask it at the end. So now we have the presentation by Mr. Grishko on Ukraine, pros and cons on dispute resolution. Maybe Sergei will find any cons. It will be interesting for us to learn about. I'm aware of my extreme responsibility because I'm in a step in between you and very tasty coffee. So I have to do it very efficiently, like our international arbitration commercial court works. And so I have to be very cautious about that. So Larissa already left, but Mr. Selivon is still here. I would like to talk with you about, well, the discussions were so interesting, especially by Alexander. I'd like to talk about the future, about our future peace, our victory of Ukraine, and then we're going to start the rebuilding of our country, and we are going to think about how to make Ukraine even better country for living than it is now. And the issue which has been under discussion for quite a long time is it possible to resolve investment disputes in Ukraine, just in principle, between the government and foreign investors? And here we're going to discuss it. So investment arbitration is mostly defined through the dispute between two parties from two countries, when there are some international legal frameworks and each party has its guarantees, and one of these guarantees is the investment contract, so that the investor can approach the government of the country where it made an investment without first approaching its own country. And most of these disputes are mostly considered in Washington, D.C., and there is an international organization there. It is under the umbrella of World Bank. They have a special procedure. And this is a decentralized procedure. So the actual case can be physically considered in, for instance, in Paris, like I once took part. But the actual jurisdiction is not defined for such a case. But some cases are considered according to ad hoc procedure, and most of these investment disputes are considered at some of the international organization, and they do not mostly include these agreements on protection of foreign investments. Sometimes there can be a clause on consideration of the cause at a specific country, which is a part of the UNICITRAL convention. So who is to decide? So if the dispute starts and the suit is filed, and if it is UNICITRAL, that's ad hoc. If it is, we speak about Stockholm chamber, that's maybe third in popularity place. Then it is the board of the Stockholm Arbitration Court considers it. What are the factors to be taken into account? It's about the neutrality when a dispute is being resolved. It's about reputation and recognized arbitration. Lack of bias of the legal system and the national arbitration legislation, and the practices of enforcement of the arbitration decisions. And one more I would like to mention: reputation. So here we're going to move forward. In 2015, the London Royal Arbitration colleague, they issued London Centenary Principles. The idea of these principles is to define how to select a jurisdiction, a country where arbitration can be done. So what are the criteria for a jurisdiction? And I think it's the best attempt to identify and to define this criteria for selecting a country or jurisdiction. And you may see it includes legislation, judiciary system, legal expertise, experience. And then the opportunity to choose representative, premises, ethics, education. So we can speak about these principles more. What about legislation? Legislation must be clear and concise, modern, to ensure the selection of arbitration as a way to resolve disputes. And the framework must be set, regulated. The intervention of the national courts must be limited, and there must be a balance between the confidentiality and transparency. So if we have most of our cases which are confidential, but in North America, for instance, many investment disputes were considered over there in North America. They're all public there. And when the first investment disputes started, especially against the United States, we found out that society wants to know about the essence of these disputes. Like, for instance, the laws or acts adopted by the Congress, U.S. Congress, how could these laws be resolved by some unknown three people, like they said. So it must be independent, competent, and efficient, and it must respect the selection of arbitration as a way to resolve the disputes. And I think it's very important, and I think the recent decision is a very good benchmark to show this respect to on the sides of the parties. Legal expertise, what does it mean? Is the pool of lawyers who knows what the international arbitration is, how it is different from the regular court procedures. It is important also to choose a representative, so without any limitations. And here we are okay. I think we have a better choice even in the regular courts, because in the Ukrainian court, it's just a Ukrainian lawyer, licensed lawyer, can be selected. The arbitration court is much more has much more freedom, and the selection must be convenient. And of course, it's great that you can select, for instance, Paris and London, and then do some shopping there in Oxford Street or in Champs-Élysées, or to have a boat trip over Danube. And if the one of the things at the London Royal Arbitration Court about the immunity of these arbitrators. What is important for there is no specific legislation for investment arbitration cases. They are all considered according to the general procedural norms to be applied in the international arbitration practices, mostly in compliance with the international organizations procedures, like anti-central. And now there are quite a lot of arbitration institutions which develop their own procedures or annexes to procedures for investment disputes, because they have their own peculiarities. And as for cancellation of decisions, they're just these decisions are cancelled like regular in cases. And if you look into some cases from the U.S., there could be some foundations or reasons for cancellation of these decisions. That's the cases of corruption or biased attitude or conflict of interests, or, for instance, if some specific provision was violated, or if an arbitrator abused his powers or her powers, or the timelines were not applied. So, and as far as I know, that within the recent decades, this violation of the timelines were not used for cancellation of the decisions. France is maybe the second. In Europe, it's the first jurisdiction in terms of popularity to consider investment arbitration cases, and the general causes for cancel the decisions. That's about the mistaken choice of jurisdiction. Then, when the arbitration court was created with the violations of the procedures, or the authorities, the proper authorities, were not applied in the proper way. The Netherlands, that's one of the most known places, because Yukos case was considered there, or Naftogaz against Russia case was also considered there. And the Article 1065 of the Civil Procedural Code of the Netherlands establishes like the same rules. Sweden, the same law on international arbitration sets the same criteria, which are very similar to our clauses, and we have to say that U.S., France, the Netherlands, and Sweden, they have their own types of legislation, but they don't have the law like we have here in Ukraine. So they're quite different. Switzerland is quite a popular jurisdiction. Maybe it's the second in Europe in terms of popularity, and it's about the federal law on international private law. They include the specific provisions to cancel arbitration judgment, and you may see how they are defined. So, in principle, Ukraine has gone a certain way, and we have the specialized law to identify a jurisdiction for disputes resolution, but there are some issues to be improved. I think if we're going to have some investment dispute case to be considered in Ukraine, I don't think there will be any problems, but I think the law on international commercial arbitration can be added with the clause on the specific details about the disputes of their enterprises with international investments. International sessions can be resolved in a proper way. So I think it could be a good idea to create a special procedure for investment disputes at the Ukrainian International Commercial Court of Arbitration. I think it makes sense, and I think if we, as far as I know, that investment disputes are not likely to be massive in Ukraine, because Eastern Europe is not the very popular place for resolution of such disputes. So it's I think when we had our reform of judicial system in Ukraine, I was in the process of providing my suggestions, and we saw our quite high ranking on being the potential place for arbitration. And I was told that Ukraine still cannot have a higher ranking than Czech Republic, and Czech Republic has problems. but I think we can work on it. And it is great to have the representatives of the Ministry of Justice of Ukraine. They could also support the development of investment arbitration in Ukraine, so that to create a specific procedure to be included into the competences of the International Commercial Arbitration Court of Ukraine, so that these disputes could be resolved here. Thank you for your attention, and thanks for the fruitful discussion. Thanks, Sergey. I think we're going to finish our panel. I would like to ask you a question. From what I heard, you mentioned the key criteria on ensuring the efficiency of the arbitration, and from what I heard, and you just think that Ukraine can be a potential place for investment arbitration cases. So can you hear me? Yeah. So I don't think there are actual cons, but there are some obstacles, because we don't have the specific procedures at the law. So we are speaking about that, what the steps should be done in order to become such a place for investment disputes resolution. Could I make... So I would like to ask a question. Alexander, it is great that Mr. Selivon asked a question before, that these draft agreements, which are now being considered with foreign investors, and if we look into our national law on the national laws of public-private partnerships, on law on concession, for instance, Article 19 of the law on the significant investments, it includes a list of all the alternative ways how to resolve disputes: mediation, expert evaluation, and arbitration, and arbitration outside Ukraine. So everything. So an investor can choose, but those investors who approach you, how do they select? What sort of how do they select it in the agreements? So if we're going to have the first agreements to be signed, and as soon as they are signed, then I will have the opportunity to comment upon it, because I don't have the already signed agreements, and therefore I respect my audience. And so we're going to wait for this moment, and hopefully at the next hearings I will be able to inform you. Is it okay? Yeah, okay. But it would be great if the national arbitration institution would be mentioned in such contracts or agreements. I will also give the questions online. Thanks, Ina.
The spokesman of the National Association of the Lawyers, continuing the discussion with Mr. Serhiy and with Mr. Alexander Milenchenko. So, Mr. Serhiy, both of us are lawyers, so we understand that legislatively, from the legislative perspective, there is no perspectives for Ukraine to be the platform, neither on the legislative level nor on the level of the orders, decrees. So I have the question. Shouldn't we do a pass in the Ukraine Invest? Unfortunately, it's not a legal entity. It's like the entity next close to the government. Shouldn't we do on the basis of ECAC and Ukraine Invest and potential investors to make the step further, not to be worse than the Czech Republic? Today we have all the opportunities. And then the question to Mr. Milenchenko. So why do you why understanding the importance of investments, why you are not talking with Ms. Sverdenko about protection of these investors in Ukraine? Because we trust Ukraine, and Ukraine is a powerful country where all these investments go. And then logically, Mr. Sergei, Ms. Inna will give the opportunity, and together with the Minister of Justice, they will be the part of the group where all the opportunities are available for the ICAC to be able to resolve, plus Ukraine, plus investors. So we care about us. On a big broadly speaking, Mr. Savillon, I will allow to use familiarity. So we care not about these. So we care about the investments. We have to protect our country. So Mr. Milenchenko has raised this, and Ms. Sverdenko has raised this question, and maybe the next time we will have the ready platform for the dispute resolvement, Ukraine plus investors. So what is the issue now? What is the obstacle? Let's call her together. So let me start. I think that I was trying to answer that, and then the only thing we could do is that in the framework of the arbitrability, and the rest, I guess we have the institution, the experienced one, for which works operates for more than 30 years. We have enough good court system, quite experienced, well, and we have the good legal system. We have the legal corps who are able to resolve this issue. But that is a question for the question of the trust to Ukraine as a state. And here it is important to remember that Ukraine, till recently, was considered to be a very corrupted state, a failed state, and a country 404, well, so to say, considered, but in fact that were the Russian narratives, and they were well spread here in the Western media as well, and sometimes they are trying to use these narratives, and therefore we have the question of how to persuade the investors that here, if they are investing their money here, that these disputes can be considered in Ukrainian courts if these kind of issues appear, or in the National Arbitration Institution. And here I would like to remind you this saying that in the environment of the professional arbitrators, there is a saying that arbitrate agreements are the agreements with champagne. So the last thing businessmen think when they are concluding the agreement is about disputes. First of all, they think about how to build their business, how to have beneficial conditions for both, how to get richer, and the disputes is something that is in the very end. So yes, indeed, we have to include something about disputes, so that is something on the last thing they think about. So as Mr. Alexander said, and here I'm passing the floor to him, maybe he will say a few words here. Thank you very much. Well, you know, that is the discussion which is worth hours, because yes, indeed, some aspects of this work were mentioned. The trust, you remember the famous Francis Fukuyama's work, which is called Trust. And there are the things which our future is based on. We have to be trusted. This is the thing. So here I'm going out of the framework of the topic of the question you asked, and all of us are working on it. And right now we are forming some of the aspects of the trust to us. And Ukraine Invest, believe me, every day working with investments, with ambassadors. I'm not going to name the name and to tell the names. And they are telling me, you know, during the war, one of the ambassadors says there was a missile which had Odessa monastery, but we will rebuild it. And I know and who will do it and where we will get money for. And the other ambassador who comes, the next ambassador, he came himself with his team of financial advisors, and he said that we want to do something which we didn't have in the agreements we had with Ukraine. The same about Japan. We work on trust, and because the right to choose is the right of the investor. The investor has to have the broad spectrum. Together with Mr. Mikula, with Ms. Inna, with you, we have to form this trust. And to put it not just on the political, but on any kind of component. It has to be the part of each component, and they have to see us as reliable partner. And here I'm coming back to the issue that we were working for 1 year with Japan. Japan is a closed country, and Japanese are not allowed to come to Ukraine during the war. And yesterday, when signing the agreement with JETRO, I have counted 23 Japanese who were sitting in front of us in this small room. And that means that the ice is breaking down. And I see no other option. We cannot take their slaves and force them to come here. That will work against us. And therefore, everyone on his or her place, and that is something I tell to my staff. And sometimes they call it. The investor has called me at 11 at night, and I want to sleep, and he's asking me the question. And I'm telling them, you have to be patient. Yes, it's not a working time, but we have to trust. For I start our meeting in Invest Ukraine with these words: we have to build the model where Ukraine will be not on the level, but better. Best of all, we have the chance. Why? Because we have the bravery of our defenders. It has attracted a lot of attention. And they are the ones who we have to thank for this opportunity to be on this forum. We have created an incredible aura around Ukraine, and that is something we have to rely on. And I think no other option. Thank you. Thank you. But besides trust, we have to join our efforts, and not only the institution has to talk about it, but also the authorities. And also another thing I didn't answer. So I have the meeting planned with Ms. Yulia. I will tell you words, and I will support. And please, the same words from us. One very, very brief question. So everyone is silent about this question, so I want to ask, and thank you very much that Mr. Roman Babi is still with us. And as Ms. Vasil Kratushev has said, in these whole different significant decisions were made, but recently there were two events. The first one, USAID presented their updated report with the results of the analysis and how the commercial disputes are happening, but at the same time, they did not talk about investments court. And recently we had the meeting of Mr. Maslow with the Association of Legal Association of Ukraine, and he said that at the moment this option is not rejected. Considering the fact that we have Mr. Roman and the representatives of the legal corps and of course the practitioners, maybe let's make additional cut and let's try to answer that, and maybe finally we will get rid of the options which for some reason is still on agenda. And therefore my question is very brief. So what is your attitude towards the separate specialization and some investment court in the framework of the court branch, the special court one, or maybe arbitration is better? That is a question to Mr. Krat, because you did not address this question to anyone, because recently this question was discussed in December. Yes, I was here. So you were here when the judges were very active, and yes, you were there when the head of the Supreme Court was. And there was a legal practice, and they were talking about the investment court. No. So personally, my opinion, all these things, we had the poll, and I wrote in the poll. So all of these things, everything has to be passed over to the cassation court. Very simple answer. Cassation court, due to the fact that it controls arbitration, it is ready for these kind of things. So it's very obvious. So if we think about something newly established, in this case, we are competent in the arbitration. That's very easy, simple. So I'm very sorry. We have one question online, and Mr. Miss is online with us. We have two very interesting questions. The Ukrainian arbitration is not well represented on the international stage. Do you think that, Mr. Mistelis, that the sources of the rates support the dominating of the Western arbiters? That is the first question. Maybe I will ask the questions in turn. So the first question, Professor Mistelis. So when you were describing the criteria for selection of arbiters and the institutions and how it affects and favorites. So that is the question online, please. The floor is yours. Could you answer?
Thank you. First, if I may, I would like to make a small comment on the questions and the discussion that has taken place just before. I think the idea of making Ukraine a very attractive place for investment arbitration. Ukraine, of course, for reasons which is completely outside its control to some extent, is in a state of war. But as it has correctly been said, there's a lot of very goodwill about Ukraine. So if I were Ukraine at the moment, what I would be doing in addition to negotiating investment contracts with JETRO and other major organizations, I would be revising and drafting new BITs which could possibly involve investment arbitration taking place within Ukraine, subject to ICAC specific rules or other. And I will take quite a bit of advantage of that goodwill that is out there. Now, in the specific questions that have been asked, I think, yes, I have been working on projects on Ukraine arbitration since the early 2000s, for about 20, 25 years. We did projects with Kiev Mohyla Academy, we did projects with Taras Shevchenko University, and also with Lviv University. Where I think the problem is in Ukraine is that the original sort of scholarship was influenced by CIS and Soviet scholarship. And then there was quite a bit of attraction towards French or German legal thinking, where traditionally the academia was being sort of directed. For better or worse, in the last 20 years, a lot of the development in the scholarship of arbitration and arbitration as a practice comes from, with all due respect, from Anglo-American world, but also Switzerland. And I think this type of dialogues have not been developed very much. I know that City UK has engaged recently in a project which involves ICAC, I think, to modernize arbitration in Ukraine, and is credit to ICAC that as of March 2022 has resumed work and provided a lot of online services. It's information, it's publicity and marketing, and I think that hasn't come across very well. People talk about the other things about Ukraine, which are not necessarily very positive, but there is a scope for the Ukrainian community to do much more. And in all fairness, the Ukrainian Arbitration Association has profiled itself quite well internationally. There's quite a bit of Ukrainian arbitration diaspora at the moment, including in the UK. And there's a lot of positive attention at the moment. But one needs to grasp that moment and build on it, build on this building block to get where we need to get. Now, I wasn't entirely sure about the very last question, which is about I think, on the criteria of selection and favoritism. Yes, I understand that if I understood the question correctly from the translation, there has been often critique in arbitration that institutions have had a rather closed roster, and if institutions were to make appointment, the appointment was made in favor of people who are very close to the institution. So the idea of opening up the roster is certainly something that a lot of people would expect. And I think also promoting the youngest generation of arbitration lawyers, of which there are plenty, and indeed excellent younger arbitrators in Ukraine, that will sort of address concerns that people might have had about favoritism. So relax the roster, open up the roster, and make sure that whenever you do consider appointment of arbitrators, consider amongst others a younger arbitrator who can bring perhaps a slightly sort of fresh or more international perspective. So you really have a wonderful young group of arbitration lawyers in Ukraine.
Дякую, пане Мистеліс.
Thank you, Mr. Mistelis. We could continue this discussion, but we have trespassed all the timelines. I'm sorry. We don't have time already, and we don't have this time. I would like to thank all of our speakers, our respectable guests who took part in our hearings. I would like to thank all those who asked questions. I would like to apologize that we cannot continue this discussion right now, but at least those who are present online, we could continue having some coffee and tea. Mr. Mistelis, thanks to you. It's a pity you are not with us, and we really hope that you will be able to attend in person the next hearings in peaceful, victorious Ukraine. You can come. So let's talk about the timing. So let's do our break for 20 minutes, not 30 minutes, but 20 minutes for coffee break, and get back here to work. Thank you. So let's set it exactly when we're going to. So 16:10 that we're getting back. So 20 minutes. We have 20 minutes. So 1 minute. So we're going to return to 16:15. So we are a bit out of schedule. deputy head of the International Commercial Arbitration Court. And our first panel mostly looked into future. Our second panel looked into what we're having now, today. Those reality, those challenges that arbitration courts have, Ukraine has, Europe has. So first of all, the name of the panel, the impact of the international conflict upon arbitration. Today, we are honored to greet our great speakers that we managed to engage for this session. And this great panel will provide us an opportunity to discuss these issues from different perspectives. So first of all, from the perspective of the government, how the Ministry of Justice sees the issues of sanctions, what the challenges are and the problems are. On the other hand, the perspective of judges upon sanctions. Then the perspectives of legal advisors and lawyers. And of course, from the position of arbitrators, because many of our participants have this experience to take part in this disputes resolution, commercial disputes resolution. I would like to introduce our speakers, and I will introduce them according to how they are mentioned in the program. The Deputy Minister of Justice of Ukraine, and before that, the head of the Sanctions Department, Inna Bogate. So let's read Inna. Inna is directly related and responsible for developing and implementing government's policy related to the court cases on sanctions. And currently, she is deeply involved in these issues. And she is also engaged in supporting the register of damages and creating a compensation mechanism, which all of you probably know, and that's a very important thing for Ukraine. Oleg Vaskovsky, the judge of the Cassation Commercial Court of the Supreme Court. He's a professional judge with 20 plus years of experience. He is also directly involved in developing and implementing issues related to sanctions within the decisions of the Supreme Court, and also one more member of the decision on arbitration court that we mentioned today. Also, we have a senior partner of the Pinsent Masons firm, Michael Cottrell. He has been working for more than 10 years in the area of commercial disputes resolution, representing both private companies and countries or governments in compliance with different procedures, ICC, UNCITRAL, all those arbitration procedures. Michael was directly engaged in the cases related on application of sanctions, compensation of damage, including those sanctions imposed on Russian Federation. Michael, he's going to join us soon, hopefully. Our next speaker is Maria Kostitska. He is the head of the arbitration practice. And let's meet Maria. Maria is the head of the arbitration practice and the partner of the law firm Winston & Strawn in Paris. She's a lawyer. She has a license for being an attorney in DC, US, in England and Wales. Marie is one of the key partners in many commercial disputes around the world, including at the Center on Commercial Disputes Resolution in Washington and Stockholm. She was also following cases on imposing sanctions at the court in Stockholm. One more speaker, Olga Kostishina, advisor, the head of the practices of international arbitration at LCF Law Group. She has more than 30 years in the practices of resolution of commercial disputes, including representation of the governments and countries in order to support foreign investments. Olga also took part in the development of the procedure on working with WTO, and she also represents Ukraine in many commissions of the UN on UNCITRAL, and also taking part in the USAID project. So, dear colleagues, we have a brilliant panel of speakers. We are looking forward for a great discussion. Let's start from the judge's perspective. Mr. Waskovsky, your perspective, the perspective from the side of the judiciary system on these issues. Thank you for this invitation, and I hope that my presentation will be interesting for you from the perspective of the practices. And arbitration courts or arbitrators can make some conclusions, because it's about the legislation under war conditions, and we are developing these novelties at the background of massive damage and destruction of our country, and it is quite new for us, and it is quite difficult for us to develop these norms, and it is important how to see how they are applied. If I mean the legislation of war, I mean those laws related to losses. I will not expand on this topic because it's quite a big topic. Then, and sanctions and moratoria. Why sanctions? Because we have a law on sanctions. It has been valid, this law, since 2014, and there have been many practices undertaken under this law. And since 2022, we had a new act which introduced the notion of moratorium. That's the decree of the Cabinet of Ministers on the 3rd of March on ensuring the protection of the national interest of Ukraine for further future of lawsuits of Ukraine as related to military aggression of the Russian Federation. And from the perspective of this very document, I would like to present some of my arguments. So let's start with some legislative framework and some of the laws which regulate these issues. For instance, the law on sanctions from 2014 on introducing some limitations for on the issues of the debts of the Ukrainian defense industry. And so then the decree of the Cabinet Ministers of Ukraine from March 2022 on ensuring protection of the national interest for future lawsuits. And it's a very interesting notion. It's the moratorium is the civil term. So anyway, you translate it. So it's something which delays or postpones. So all civil law professionals understand that it's about postponement. Although the legislators have a bit different meaning for that, about prohibition. But from our perspective, it's the postponement aspect which is important, because here we have future lawsuits. So it's meaning about the preparing for accumulating some data for future work, and so we are using this term in this context on moratorium. When we started to discuss about the application, we had some concerns about how to apply this decree, and because it's quite a large-scale moratorium about the mandatory implementation of mandatory decisions related to the actions of the aggressor country, in compliance with the list of the issues which are here on the screen. It's quite big. I will not go deep into it. It's different from the sanctions list, because the subject matter and they are different from the legal perspective. I will a bit change the topics from. So about the subject matter, about the mandatory aspects, about the moratorium on confiscation of any assets or land or property. About So that's about the sphere of application of this moratorium. About the case law, the key case, sort of like a benchmark case, it's the judgment on Smila electric mechanical plant, and this decree was directly applied. So there were requirements from the creditor on bankruptcy of this plant from Smila, and creditor was from Russian Federation. So they filed a complaint on that, and this complaint wasn't considered, take into account the decree of the Cabinet of Ministers. But when we went deep into the semantics of this moratorium, we had to discuss this postponement. So we made some conclusions. That means that since the start of this moratorium being in place, then these parties had to apply the provisions of this decree. So it's about the implementation of these sanctions. So we had a bit different interpretation. So irrespective of what relationships do you have with the party, this moratorium must work. If it postpones the implementation of the liabilities, but if there is no postponement of the term, then the court doesn't consider this complaint. That means that it postpones the consideration of this case until it is possible. So the issue here, and I mentioned once about this moratorium on bankruptcy cases, the problem is while refusing the creditor's demands, in this case Russian Federation, we do not provide the opportunity for the creditor to take part. But the point is that that it is time relevant, and so if the case is closed, what could we do with the demands of this claimant? And if this claimant didn't have his claims to be attended, what could we do with that? How can the government of Ukraine or Ukraine as a country can resolve that in future? Then probably in future there will be some new framework. But the key thing here is about the protocol, about the procedure to have, because now we had, if we liquidate these entities, then there is no satisfaction for the creditors from both Ukraine or from Russian Federation. So this analysis of the norms was conducted. So we started to analyze these legal norms, how it must work, and what could be the consequences for the parties when this decree is applied, and how we do not have the final view upon how it can be resolved ultimately. And so the issue of the government is vital. So I bit diverted from the issue, but we're going to discuss it as well. We have here representatives of the Ministry of Justice, and I asked this question already for the second time. Maybe you will consider it afterwards. So we here you may see some of the decrees of the Commercial Cassation Court judgments. They related to different issues. These were commercial disputes, contracts, implementation. You may have a broader look into these judgments of the court. But I would like to discuss the decree of the National Bank of Ukraine on the work of the bank system of Ukraine during the martial law. The point is that this decree is in compliance with the decree of the Cabinet of Ministers 187, although the decree of the Cabinet of Ministers was actually adopted later. But this decree of the National Bank of Ukraine develops the provisions of the Cabinet of Ministers, how to actually implement it, about the blocking the accounts, about the this decree can be applied both to Russian Federation subjects and Belarus structures or entities. So, because the previous document was applied only to Russian Federation. One more decree of the Commercial Cassation Court about the mandatory so about forcing banks to so we had a situation when the Russian Federation entity paid to the Ukrainian firm, but we had the decree of the Cabinet of Ministers, and then the money didn't reach the account of the Ukrainian company. And so we had a dilemma here, how we're going to apply this norm, because, well, ultimately it must be beneficial for our companies to get their money. And so it must work irrespective of other conditions. So one more interesting case That's the case on bankruptcy of the Belarusian oil company, and that was one of the key exporters of oil products. And we had a situation here when the bank didn't made a financial transaction, and the company was owned by the Belarus company, and so the transaction was not made, and the bankruptcy case was opened against this company, and so we had creditors. The creditors filed for returning the funds because the funds didn't reach Belarus, and therefore these Ukrainian companies demanded return of the funds to Ukrainian companies. So both parties were interpreting this both decree of the Cabinet of Ministers and the decree of the National Bank of Ukraine in different ways. So the key ultimate outcome must be about the economic benefit for Ukrainian companies. About some problem issues on application of this decree, and here are my ideas. So in general, I'd like to say that we have very few practical cases on application of this decree. Probably we should have some amendments to these policies, and we are on the way on further progress, and we are waiting for peace and our victory. Thank you, Oleg Viktorovich. Thank you, dear colleagues. Oleg has to leave us, so let's set the questions for the end of the session. But if you have just one question specifically for Oleg Vaskovsky now, it could be asked. No questions. Okay, great. Thank you, Mr. Vaskovsky, for being with us. We have our this presentation. So there were court practices on application of the decree 187. So you can approach us to get more information. We are moving forward. Now I have the privilege to give floor to Inna Bogatых, Deputy Minister of Justice, who will tell you about absolutely unique things about what the Ministry of Justice works in the area of sanctions applications and the things that the business is concerned and all of us. So the floor is yours. Good afternoon. First of all, I would like to thank you for the invitation. It's a big honor for me to present for such an honorable audience. I would like to say that today I have my former professors, my fellow mates from the university, and those colleagues with whom I worked those who worked at the government when I was in the government. And there is a lawyer who actually advised me to join the ministry. And the lawyer is a must-have to advise on this issue. So today I'm at this event with my lawyer. So thanks. And I would like also to add that in fact, today we have here a very positive audience in this room, because maybe the actual way how we operate our sanctions department, our international resolutions department of the Ministry of Justice, we pay a lot of attention to the issues of disputes, to sanctions, to arbitrations, to the disputes resolutions. And obviously that most of these issues are related to Russian Federation and those entities related or connected with the Russian Federation. So when we discuss today about the investments or attraction of investments, I'm really happy that we are convinced that victory is nigh, that Ukraine will be rebuilt, and we will be able to ensure protection for everybody who is going to invest in Ukraine. However, today I have such a strange dilemma, because sanctions is not about the protection. That's actual intervention or breach of the property rights. And therefore, I would like to tell you more about that. Well, really, sanctions per se, since the start of the war, have become a very important instrument of the international policy, because no other instruments are actionable to pressure the aggressor. And of course, I will mention these other instruments used in the international arena. And this is the reality. When other instruments do not work, then sanctions is the only way of effectuate some quick pressure over Russian Federations or those entities which support Russian Federation, and ensure that the Russian Federation get profits in order to enable further aggression against Ukraine. So here at this slide, you may see visually the number of sanctions applied by our country partners, by the US, United Kingdom, and the EU, also Canada, Japan, Australia, Switzerland, and other countries. But here, you cannot see the number of sanctions applied by Ukraine. Because if we can... so here at the slide is around 2,000 persons. Ukraine sanctioned more than 14,000 persons. So the Ukraine's number is much higher. Anyway, we tried to illustrate with this slide the response from the side of the international community and our country partners, how they were quick and how adequately they responded in terms of applying sanctions against physical persons or some industries, sectoral sanctions, and to limit its economic capabilities to conduct an aggressive war. So I will divert a bit. Why sanctions? Why other instruments do not work so far, although Ukraine, in cooperation with other partners, undertake colossal efforts in order to build international institutions which will restore justice in the world. I'm using deliberately these high words because countering armed aggression is about restoring justice, because aggression must be punished. And all those persons who supported this aggression must be put to liability. And you know that this year for Ukraine is the year when we ratified Rome Statute, and the Parliament of Ukraine ratified Rome Statute, and the previous declarations were made even as in much earlier, but the ratification is still in progress. But the Rome Statute was ratified in September. The law was signed by the president on the 24th of August. That was the Independence Day of Ukraine. This year, the implementation law was supported by the parliament, and it is this law which will be crucial on full ratification and implementation of Rome Statute, and we expect the finalization of the ratification on the 1st of January 2025, when Ukraine will become the member of the International Criminal Court. However, till now, even the ratification of the Rome Statute doesn't resolve all the issues related to getting into liability all those who are responsible for aggression, because the crime of aggression cannot be considered by the International Criminal Court in relation to Ukraine. International Criminal Court issued 6 warrants of arrest for the senior leadership of Russia: Vladimir Putin, Sergei Shoigu, Valery Gerasimov, Maria Lvova-Belova. But unfortunately, even this issuance of warrant results in the response of those countries who are members of ICC. We remember about the visit of Putin to Mongolia, when the country didn't respond and Putin wasn't detained. So this visit will be considered in December 2024, when the assembly of the ICC members will take place. So when discussing the issues of the International Criminal Court as a key entity to bring to liability, however, there are no enforcement mechanisms so far. So therefore, we have to consider alternative mechanisms. So Ukraine also works on creating a special international tribunal. And the Ministry of Foreign Affairs is mostly responsible for it, but the Ministry of Justice is also involved in attending the meetings with our international partners and created the special tribunal. 41 countries support the creation of the tribunal. Still, there are some legal issues around it, including the immunity of the heads of states, about how to override this immunity of the heads of states. And being certain that the international community will find some solutions to bring to the liability the country aggressor and the physical persons, those who took decisions on aggression and who continue to take these decisions. Still, there are some legal issues to be addressed related to that. So I will go to the next page, so not to forget what I wanted to discuss. So, alongside with Ukraine's development of legal instruments to bring to liability Russian Federation, its leadership, and all the those who committed war crimes. At the same time, also there is what could be direct instruments to bring to liability, and what we mention in every claim and every lawsuit. That's about the right of Ukraine of self-defense. The right of self-defense is defined by Article 51 by the United Nations Charter. It is clearly defined that if the country is directly subjected by aggression until the moment when the United Nations will undertake the action to restore peace and security. Therefore, Article 51 provides Ukraine with the right to legitimately identify countermeasures and self-defense as a response to direct and open aggression. The same way, the right to self-defense is defined in the articles on countermeasures in relation to wrongful doing. So this project is being drafted by the UN bodies. It is still not ratified document. However, this draft of these articles since 2001 are also sources of law, and they were used to justify the right of Ukraine for self-defense. So these two articles, Article 21 and Article 22, it is repeated that a country has the right to undertake adequate countermeasures to protect the country. What about the case law on countermeasures? I would like to mention, first of all, we don't say that the right of the country to apply sanctions is an absolute right. First of all, the country must deliberate and justify the use of sanctions while limiting the rights and interfering and breaching some rights. So the country or the government has to act in defense of its rights and in response to aggression. On the other hand, it must maintain its rights within the lawful measures and instruments. I would like to draw your attention to the judgment of the tribunal's conclusion on air services agreement of United States and France on the 27th of March of 1946. And it was stated that if a situation arises which, in one state's view, results in the violation of the international obligation by another state, the first state is entitled, within the limits set by the general rules of international law pertaining to the use of armed forces, to affirm its rights through countermeasures. What about the forfeiture or confiscation of sovereign assets? Here we have some documents from other countries, and they're related not only the forfeiture of sovereign assets, but also to private assets of those persons who support the Russian aggression. I would like to mention the confiscation of sovereign assets is a very complicated legal process, and it is widely discussed, and there are many issues and challenges to be resolved in future. The international community is very cautious about the forfeiture of sovereign assets now, even under conditions of armed aggression against Ukraine. But we have to keep in mind that even with these concerns expressed at every international meeting, the international community has made a big step forward. For instance, the United States adopted an act on rebuilding economic prosperity and opportunity for Ukrainians Act, so REPO, which provides the right to confiscate the sovereign assets of Russian assets, and so these funds can be then channeled to the special fund to rebuild Ukraine. And there is also a Canada Special Economic Measures Act under international law, which allows seize Russian assets. And it is especially important that these assets include the assets belonging to the private persons. So Canada and Estonia, and I will tell about Estonia more later, so they have the laws allowing confiscation of private assets or of private persons. And Canada started the first case, and it has been blocked by the counter counter case. So Canada cannot demonstrate how this law can be implemented, because the first case, the first lawsuit on airplane Volga-Dnieper was blocked by Russia. In May 2024, the law was made in Estonia on seizure of Russian assets, and this law regulates these amendments on this seizure of assets. So we are very grateful to those countries which developed the mechanisms of impact, of influence. So they say that when there is an open aggression against Ukraine, then both Ukraine as a victim of the aggression and those countries which support Ukraine have the full legitimate right to adopt those policies and laws which include exclusive conditions to breach the property rights, which could not be possible otherwise. Therefore, we are grateful for every country who apply these sanctions and countermeasures to repel this Russian aggression and apply new legal instruments. What about international compensation mechanism? I don't know. So I will touch very quickly upon this. So the key instrument to be used, and actually has been already launched on restoring damage. That's the international compensation mechanism. An international compensation mechanism consists of the register of damage or losses, and it has been launched already for various categories of damages and losses. The next component is the Application Review Commission. It is still, the creation of this commission is still in progress, and I hopefully that in 2025 this commission will be created. It's the intergovernmental process, and therefore it takes quite time. So these processes are not so quick. And the compensation fund, the third element of the international compensation mechanism, which must become the source of payments according to the decisions of the Commission to cover the damages inflicted as a result of Russian aggression. The creation of the register of damages and in general the resolution of the UN General Assembly, which was adopted on the 14th of November in 2022 by 94 countries, they recognize the need in creating the international compensation mechanism and the register of damages. And the European Union also, so the Cabinet of Ministers created this mechanism, and the first meeting already was held in The Hague on creating the next element, on creating the commission, the Application Review Commission. And 55 delegations from countries took part in this meeting, and we agreed on, so the parties agreed on creating this commission till the end of the next year. And it is important to say, I would like to emphasize the fact that it is it's always discussed about the legitimacy of using the countermeasures as transferring Russian assets as compensation. The group of international lawyers created a document on the use of such mechanism in order to restore the damage of Ukrainians, and this memorandum was signed on the 20th of November of 2022, and again, the mechanisms which I mentioned today, they are supposed to be created in future, and they will be fully implemented in future. However, it is just sanctions which have become the quick response mechanism, both for Ukraine and for country partners in terms of Russian aggression. So I want to get back.
Speaking of the difficult, different types of sanctions, just a moment. So speaking of different types of sanctions, then sanctions are personal sanctions and sectoral sanctions. And of course, personal sanctions are for against a person which has the signs or creates potential or real threats to the state, and sectoral one apply to some certain sector or to some certain state. On this slide, we can see the part of the quoted law on sanctions, where the general justification for sanctions is shown. And beside that, the sanctions can be applied also according to the general resolution of Ukraine, the regulations, the orders of the European Union, and the law of Ukraine sanctions. Besides that, there is the sanctions on the assets, which has to be exempt according to the Supreme Anti-Corruption Court. And why? The situation, why in fact, how did these sanctions appear? So that was a response to the Russian aggression on the full-scale war in Ukraine, and of course, some certain lack of punishment for a long time led to these consequences, and some, I would say, even softness of the international community on all of these violations of the international law and the international traditions, which were performed by the Russian Federation for quite a long time. And it's absolutely well known that the Russian Federation at the moment is the most sanctioned country in the world. And if Moldova did not have any punishment for the war in Chechnya, then starting since 2014 and 2022, the civilized world applied the sanctions against the Russian Federation and the businesses and the companies. As I already mentioned, the sanctions were applied by the state partners, and speaking of the quantitative measure, the sanctions were applied by 41 countries. At the same time, international cooperation on sanctions reached a high scale when the groups of countries in a single wave, they apply the sanctions against sectoral and personal sanctions, and also the head of the state. For example, Putin was the third head of the country who was in the sanction list of the European Union. I'm very sorry, I went back. Since 2014, the partners countries imposed more than 14,000 sanctions against companies and individuals. That was a response to the actions of the Russian Federation regarding the annexion of the part of the territories and the occupation of the part of the territories of Ukraine, annexion of the Autonomous Republic of Crimea. And Ukraine, since 2022, imposed around the same number of sanctions against the Russian Federation and the subjects. So I was speaking of this slide a bit, and at the moment we have a vast experience on exchange of information and justifications and also other elements for imposing the sanctions. So Ukraine now cooperates with the international organizations, and Ukraine mirrors on the national level of the sanctions imposed by the international partners. Ukraine imposes sanctions together with the partners, so also for not to have any kind of disputes or arguments, and constantly cooperates with the partners and exchanging information on the subjects to sanctions. And also there is a big work on tracking the cases of the violation of sanctions and sanctions against those people who are helping the others to avoid sanctions. So nowadays, sanctions are the international legal tool which is implemented not only in Ukraine but also on the international level. Speaking of the legal aspect of sanctions, in this case, what I was mentioning already, that there can be no absolute will of the state when applying sanctions. When imposing sanctions, Ukraine and the ally states, they are following the principles of the sufficient justifications, the ratio of the rational punishment, and the sanctions are used on non-discrimination basement. The justification for sanctions are the actions and not the nation or something else. So the sanctions are applied for some certain period of time, and the person who these sanctions were applied to, the person can contact the initiator of the sanctions, and in case the sanctions were unfair or imposed mistakenly, they can try to explain this opinion. If the initiator does not respond or the response is not sufficient to the subject of the sanction, then the relevant decisions can be considered in the court. The nature of the sanctions is very various. Indeed, they are on the verge of the international law, on the political will of the state, and the others. So today we're talking of the legal countering of the sanctions. As the previous speaker said, the first response was the decree. The National Bank of Ukraine adopted the regulation of the funds, the transfer of the funds to the subjects affiliated with the Russian Federation. The third one was the law of Ukraine on the a compulsory seizure of property rights of the residents of the Russian Federation in Ukraine, and that is a law, the law of Ukraine on the compulsory seizure of property rights of residents of the Russian Federation in Ukraine. And this law concerns mainly those objects and the corporate rights where the ultimate beneficiary, the ultimate owner is the Russian Federation, and the law of Ukraine on sanctions and the changes which were adopted on the 12th of May 2022, and they applied the new type of sanctions that was the counter response to the aggression of the Russian Federation in Ukraine. So I will be a bit faster because I understand that I'm taking too much time. Speaking of the sanctions as of asset forfeiture into the state revenue, in this case, it is important to follow the conditions and grounds for application of these sanctions, meaning that the law of Ukraine on sanctions foresees the separate article and the separate list of the reasons when these sanctions can be applied. Sanction of asset forfeiture can be applied, and also the application procedure is regulated by the Code of Administrative Procedure, and in compliance with the principle of adversarial proceedings, which provides for the right to appeal, participation in the proceedings, and foresees all the procedural mandatory things which are happening in the normal proceedings. The sanctions sanction of asset forfeiture can be applied only during the martial law, and the sanction can be applied only when the Ministry of Justice substantiates the grounds for its application and the conditions for its application are met. Hearings, at least most of them, are public, and the court takes exhaustive measures to ensure that the parties are duly notified of the proceedings. Speaking of the statistics, at the moment, we have applied 61 claims for imposing of asset forfeiture into the state revenue. 50 decisions are adopted, and 11 cases are considered in the court. Speaking of the structure of the forfeiture assets, it is very various, and that it borrows both funds, corporate rights, movable rights, the rights of claimant, including compensation, trademark rights, domestic state loan bonds, and that are the actives which the Ministry of Justice is able to identify in the process of searching for the assets, which is one of our objectives in the framework of the procedure of assets forfeiture. Speaking of coming back to the question of today's discussion and coming back to the question of arbitration and, so to say, the balance, the mutual balance between sanctions and assets forfeiture and the international obligations of Ukraine. Then we can say that, in fact, it's quite often when it happens, and this discussion is ongoing. It never stops on the ratio of the regulatory activities of the state with the international bilateral agreements. But starting with 2022, the most recent and broad most well-spread sanction is the exemption of the assets. And now we have 72 agreements, which include some certain provisions on the settlement, and with the possibility of applying to the court and forfeiture of the assets through the court. So the question is how the sanctions are used and how the international and what about the international obligations of Ukraine. So first of all, I would like to say that everything I'm mentioning now, it does not concern our legal position as a Minister of Justice, and now in the current and in the future disputes when it comes to the assets forfeiture into the state revenue according to the international traditional law. They are doing these kind of things, who are in the framework of their jurisdiction and the joint civil interest. That is something I was mentioning in the beginning. That was Article 51 of the International Statute of Ukraine. And there are police powers, which means that the state can apply any kind of fair, non-discrimination and proportional measures aimed on the protection of the social interest, especially in the framework of considering the national threats. The doctrine police powers finds manifestation in the international investment arbitration mainly, and there are principles according to which the actions are considered to be legal. Conclusions. I would like to emphasize one thing. Despite the fact that investment agreements are aimed on the protection of the rights of the individual and their assets, it does not turn in these kind of individuals into subjects for decision-making. Investors and their investments are the objects and the objects of the agreements which are concluded between the states who are the subjects to the agreements. The rights of the foreign investors, they start with and are limited with a state which the agreement is made between, and cannot cannot exclude the national law. And therefore, considering the international investment law, investor who has a procedural right to initiate arbitration, but nevertheless it does not have an impact on the rights and obligation which one has according to the mutual decision of the state, so what is formalized by the relevant agreement. And these principles are the ones which Ukraine follows when implementing the sanctions. I would like to remind you that foreign jurisdictional areas are not the instances for the appeal for Ukraine, and their evaluation and assessment of the activities of Ukraine is quite limited. And finalizing my speech, because in fact I'm moving to the conclusions of my presentation, I would like to underline that the basis for the application of sanctions is the subject actions that contain real or potential threats to public interests and the national security of the state. Sanctions are not a method, form, or mechanism of prosecution, but a response and countermeasure to an illegal act. And they are the way to protect the society and its legitimate order. The sanctions in their nature are the continuation of the policies of the state. At the same time, the procedure for applying sanction is sufficiently formalized, requires proper justification, and must be proportionate and commensurate with the legal act of the relevant entity. And that is something that characterizes the political will of the state. The state's right to apply sanctions and forfeit assets of sanctioned persons and sovereign assets of the aggressor state to prevent further violations of the international law and to compensate for the consequences of already committed criminal acts cannot be questioned and requires immediate changes in the international law. The application of the sanctions to forfeit the assets of the sanctioned persons during the martial law is a fair and proportionate measure which limits the resources of the enemy. So we are working on the implementation of the new approaches and the standards on the right of the state to fight the consequences of the weaponized conflict. And I hope that everything I said and all the messages I've made, which I was trying to bring to you, will be considered in the correct way. Ukraine has never respects every investment which is made to Ukraine with the aim of the development and with the aim to conduct the normal commercial activities. And in fact, this kind of broad application of the sanctions became the consequence that because for a long time, and so far we do not have the sufficient procedure of the screening of the foreign investments. And I consider that this kind of procedure should be in place because Ukraine has to control the investments in every object, especially when it comes to the critical infrastructure or strategic sectors. And therefore, today, when our economy does not have any kind of Russian impact, I think that this is our homework, the homework we should have made a long time ago, and we have to control the foreign capital, not friendly capitals, and therefore we have to make the conclusion for the future. Thank you very much for your attention, and I'm very sorry if something was not clear. Please ask the question. Thank you. Thank you, Ms. Irina. Very interesting about different instruments. And the last message about the investment attractiveness of the countries, I think that we will come back to it. That is an interesting position. And now, dear friends, we are moving forward. Our next speaker, Michael Cottrell. Michael, are you with us?
Michael, can you hear and see us?
Michael, can you hear us? Michael, can you hear us? Michael?
Michael,
yes,
can you hear us?
Can you hear me?
Perfect. Отже, до слова
So the chief lawyer Pinsat company. So please, the floor is yours.
Michael, we can hear you, please.
Michael, the floor is yours.
Thank you very much. My apologies, I think there is a delay on the line. Good afternoon. I'd like to say thanks to the International Commercial Arbitration Court for the invitation to speak at this very timely and important conference. I'm going to be addressing the effect of sanctions on arbitration and some practical strategies for managing risks. I should say at the outset that my firm is active in representing European companies in proceedings against Russian entities arising out of sanctions, and so my comments today are my own and should not be taken as representing those of my firm or our clients. I must start by agreeing with the Deputy Minister that sanctions are a very important instrument of international policy, but sanctions are by their nature blunt instruments. They are tools to apply pressure on states, on groups, on individuals to coerce that target into a particular course of action. They're often introduced in the immediate aftermath of a particular event, and they are intended to have a significant negative economic or other material impact to achieve the aim of the particular sanctions regime. Taking all of those factors together, it creates the perfect recipe for the law of unintended consequences to take hold. And I think that the effect that sanctions have on arbitration is a particularly stark case in point as to the effect of the law of unintended consequences. As far as I'm aware, no sanctions regime has ever specifically targeted arbitration, or the provision of arbitration services, but the inherently cross-border nature of international arbitration means that the effect of applying restrictions in the sanctions regimes can have significant unintended consequences for arbitration. Now, I see those consequences falling into two broad categories. Some of those consequences affect the mechanism, the mechanics of the arbitral process. Restrictions, for example, on the provision of legal services affect the ability of sanctioned entities or entities from sanctioned countries to engage suitably qualified representatives. the often broad restrictions concerning financial transactions can affect the ability of arbitral institutions to receive payments from sanctioned entities or from sanctioned countries. And concerns over source of funds can also affect the ability of arbitrators to accept appointments. Other consequences, though, are of a more fundamental nature. They affect the underlying jurisprudential basis of international arbitration, really the fabric of arbitration. And in this regard, as we'll go on to see, sanctions have been used as a pretext for permitting domestic courts to render arbitration agreements unenforceable and assert jurisdiction over disputes. These issues have arisen, I think, most frequently of late in the context of the sanctions regimes imposed on Russia following the illegal annexation of Crimea in 2014, and more particularly since those regimes were accelerated in response to Russia's full-scale invasion. And I think that's the result of some unique circumstances, because the regimes targeting Russia target a broad range of economic sectors within Russia, whereas other sanctions regimes, take for example the Venezuelan sanctions imposed by the United States, target very specific sectors like the oil sector in that country. There's also been the unprecedented steps taken to effectively isolate Russian banks from the international banking system. And I think when you compare other sanctions targets against Russia, Russia is by far the largest and most economically active country against which such comprehensive sanctions regimes have been imposed. So as a consequence of that, there's a significantly greater scope for disputes to arise as a consequence of sanctions, which means that there's a significant scope for arbitrations themselves that have been commenced to resolve those disputes to be affected by sanctions as well. And so it's through the lens of Russian sanctions that I will consider the effects of sanctions on arbitration. Turning then to the effects of sanctions on the mechanics of the arbitral process to begin with. The ability of parties to engage counsel is an issue that's been of significant interest to the legal sector, particularly since 2022, when the sanctions imposed against Russia were really ramped up. The issue here is that sanctions often restrict the provision of certain services or the ability of service providers to receive payments for their services. And obviously in this context, we're talking about lawyers, barristers, their ability to provide legal services to Russian parties or to receive money from Russian parties for those services. If a party can't retain adequately qualified counsel, that obviously can prejudice its position in the arbitration, because it may not be able to properly put its case to the tribunal in the proceedings. And obviously, if that is an issue that arises, that can give rise to grounds later on to challenge the enforcement of the arbitral award. Russian sanctions regimes had initially been quite unclear as to whether legal services were included or excluded from the scope of restrictions. For instance, the fourth package of EU sanctions that was introduced on the 15th of March 2022 introduced new restrictions against transactions with publicly owned or controlled Russian entities. There were some exclusions in Article 5AA, but those exclusions only applied to transactions that were strictly necessary for the purchase of fossil fuels and other raw materials. There was no specific carve-out for the provision or transactions for the provision of legal services. So prima facie, those transactions would have been restricted by the sanctions regime of the European Union. However, in response to concerns that were raised by the European legal community, the European Commission updated its frequently asked questions document in June of 2022, and which stated that Article 5AA, the restriction against the transactions with Russian public entities, was to be interpreted in light of the fundamental rights protected by the European Charter on Human Rights, the European Charter on Fundamental Rights. Article 47 of that charter provides a right of defence in judicial proceedings and the right of an effective legal remedy. And so shortly after that clarification was provided, as part of the 7th package of sanctions introduced on the 22nd of July 2022, the EU introduced a further exclusion to that prohibition on transactions with publicly owned Russian entities, to say that transactions that are strictly necessary to ensure access to judicial, administrative or arbitral proceedings in a member state were excluded from that prohibition. Subsequently, in October of 2022, the European Union introduced an express restriction on the provision of legal advisory services to Russian government and also Russian legal persons, entities or bodies established in Russia. So a blanket ban on the provision of legal advisory services to any Russian person or entity. However, the definition of legal advisory services in the underlying Council decision made it very clear that legal advisory services do not include legal representation services in matters or proceedings before administrative agencies, courts, or other duly constituted official tribunals, or in arbitral or mediation proceedings. So the effect of that was very clearly to exclude the provision of legal services in contentious proceedings before courts or arbitral tribunals from the scope of the restriction that was introduced in October 2022. In a very recent decision issued on the 2nd of October this year, in the case of Brussels Bar Association against the European Council, the General Court of the Court of Justice of the European Union confirmed that the general prohibition on the provision of legal services does not contravene the fundamental rights of access to a lawyer, because the ban on the provision of legal services only affected those activities that related to essentially financial and commercial transactions. So the right of access to a lawyer for the purposes of judicial or arbitral proceedings, which is what Article 47 of the European Charter protects, were not affected by the sanctions. It is notable, though, that the exclusion in the European sanctions regime is restricted to circumstances where the judicial or the arbitral proceedings take place in a member state. So therefore, arguably, an EU-based law firm would not be able to provide services to a Russian party if the arbitration was seated outside of the European Union. The position in the United Kingdom is arguably more straightforward. After a period of uncertainty, the provision of legal services to designated persons, so persons and entities listed on our sanctions list, was made subject to a general license, which permits the provision of legal services, but caps the amount of fees and expenses that can be charged to the or can be paid by the designated person to the law firm or the barrister. If you go over that cap, it is permissible, but only if you have a specific license that you must apply for ahead of time. So there is a degree now of clarity as to the provision of legal services, certainly in the European and the English rules. But notwithstanding that clarity, issues around obtaining adequate representation still remain. As I'm sure you'll be aware, many Western firms withdrew from Russia in 2022 and have actively offloaded their Russian clients, citing issues of reputational risk and banking issues that make it difficult to be paid for their services. So there are still concerns over the quality of representation. And those are concerns that I must say, in my experience, have been exploited by Russian parties in order to try and argue that they would be unable to obtain justice if their claims or if the disputes were to be determined in international arbitration. However, I do think that those concerns are overstated. Following the departure of Western firms from Russia in 2022, there was a proliferation of new Russian firms that were created out of the partners and associates who had been left behind from those Western firms. So there is a pool of Western-trained, experienced lawyers with arbitration experience still in Russia, and who, by all accounts, are still doing very well out of the situation. And anecdotally, it's evident that Russian parties are still capable of retaining Western counsel. Many of you, I'm sure, will be aware of the various proceedings that Ruschem Alliance, RCA, has been involved in around the world. For instance, the anti-suit injunction proceedings that were brought by UniCredit in the English courts. RCA was able to instruct a leading law firm and instruct a barrister from leading chambers in London in order to represent it all the way up to the Supreme Court in the UK. And similarly, in a recent case, Gazprom International retained Dutch counsel in summary proceedings brought by Slavitic Invest, which is a Ukrainian company, before the Hague District Court. Another issue that arises that's caused directly by sanctions in arbitration is the ability of Russian parties to contribute towards the costs of the proceedings. Obviously, counsel fees are one of the significant expenditures in arbitration, but one of the other payments that has to be made, and it can be a significant payment, often in large cases exceeding €1 million, is the deposits on costs for the arbitral institution and for the fees of the arbitrator. Issues in this regard can arise both in terms of the Russian party's ability to make a payment due to the limited access of Russian banks to the international payment systems, but also the arbitral institution's ability to receive money from sanctioned entities or from sanction affected countries. As with payments to lawyers and counsel, steps have been taken in some jurisdictions to deal expressly with the issue of institutions being able to receive payments. For example, in the United Kingdom, the Office of Financial Sanctions Implementation has granted a general license to the London Court of International Arbitration, which allows it to receive funds from designated persons to cover arbitration costs, which are defined as being the administrative charges, the fees and expenses of the tribunal, any emergency arbitrator fees, and the fees of the tribunal secretary. And under the European Union sanctions regime, to the extent that payment of fees might constitute a restricted transaction, it's arguable that such a payment would be treated as exempt, because it would be a transaction that was strictly necessary to ensure access to arbitral proceedings. Because if the payment isn't made, particularly if the Russian entity is the claimant in those proceedings, then the arbitration won't commence. The arbitral institution won't operate the procedure for the arbitration. So institutions can receive funds, but what about the ability of the Russian party to actually make the payment to the arbitral institution outside of Russia? As I mentioned, Russian banks have effectively been disconnected from the SWIFT system. And as a consequence of that, the Russian central bank established an alternative system, the system for transfer of financial messages, which the EU, in its 14th package of sanctions, prohibited entities from Europe from connecting to this new Russian SWIFT alternative system. So it remains very difficult for Russian banks to access the international banking system. However, there are banks outside of Russia in non-EU, non-sanctioning jurisdictions that are able to connect to the Russian central bank's SWIFT alternative system. So payments from non-sanctioned entities can still be made to arbitral institutions if they are routed correctly through countries that are still connected to the Russian banking system. I do have to say, though, that this is more a question of where there's a will, there's a way when it comes to Russian entities making payments in respect of arbitral proceedings. From my experience, if the Russian party is the respondent party, banking difficulties tend to be a useful excuse for them not to make payment. However, in one case that I'm involved in, where the Russian party is the respondent party, they had argued that they were unable to make payments to the arbitral institution to pay the advances on costs, yet they have somehow been able to make payments in order to make their challenge to one of the arbitrators in those proceedings. And they've also been able to pay local counsel in other jurisdictions. Just finally, on the issue of the mechanics of arbitration, sanctions can cause real difficulties for physical hearings in arbitral proceedings. The ability of party representatives, of counsel, of witnesses and experts to travel to attend hearings can be affected by travel bans that are in place in many jurisdictions. And I think there's a significant correlation between the main arbitral centres, certainly in the Western Hemisphere, and countries that have imposed sanctions on Russian individuals. So that can make it difficult to hold in-person hearings. Now, obviously, post-COVID, we are all used to conducting hearings online. And so to a certain extent, that issue has also been reduced. However, it does remain the case that most tribunals do prefer to have at least the substantive hearing in person, so that witnesses can be cross-examined in person in front of the tribunal. And so where travel bans have been imposed, that can pose real difficulties in identifying suitable venues for hearings to take place. In addition to the effect that sanctions can have on the practical mechanics of the arbitration process, sanctions can also have an effect on the integrity of the arbitral process itself. Or to put it more accurately, sanctions can be used as a pretext to actively undermine the arbitral process. And there are 2 points that I'd like to pick up on here. The first is that in my experience, sanctions have been used to open up a new front in order to challenge the appointment of arbitrators, or otherwise attempt to cast doubts on the impartiality and the independence of the arbitrators. In the case of Ruschem Alliance and Lindy, which is the first case that's going through the Russian courts at the moment, Ruschem Alliance made submissions to the Russian courts, which were cited by the Hong Kong courts in the anti-suit injunction proceedings that were commenced there by Lindy. And those submissions, RCA sought to argue that the tribunal that would be appointed in the arbitral process would be, I quote, governed by provisions of the EU sanctions regulation. And on that basis, RCA argued they would not receive a fair trial. Now, that was given fairly short shrift by the Hong Kong courts when it was argued there. But what RCA is effectively saying is that arbitrators from countries that have imposed sanctions on Russia, these so-called unfriendly countries, are automatically unable to be impartial or independent because they are obliged to apply or will be governed by sanctions regulations that have been issued by their respective countries. I'm also aware of one case where a challenge has been raised against an arbitrator on the grounds that they were a formerly active member of the legislature of a state which has introduced sanctions against Russia, which on the Russian party's case casts doubt over the arbitrator's ability to act impartially or independently, despite the fact that the arbitrator in question had no involvement whatsoever in the passage in the legislature of any Russian-related sanctions. The very fact that this arbitrator was a formerly active member of the state legislature was sufficient on the Russian party's case to justify a challenge to the arbitrator. The other aspect of this slightly more pernicious or dangerous effects of sanctions on arbitration is that they have been used to justify the assertion by domestic courts of jurisdiction over disputes that are governed by arbitration agreements. Now, I'm sure many in the audience will have heard of Article 248 of the Russian Arbitrage Procedural Code. The provisions of Article 248 were amended on the 2nd of June 2020 in response to sanctions imposed against Russia by the so-called unfriendly states. As originally drafted, the Russian entities that were entitled to invoke the jurisdiction of the Russian court and have their disputes resolved there were parties against whom restrictive measures had directly been taken. And they were only able to invoke the jurisdiction of the Russian courts, provided that, firstly, there was no pre-existing dispute between the same parties on the same matters taking place in a foreign court or foreign arbitral tribunal, and also provided that there was no pre-existing treaty or agreement by which disputes were to be referred to a foreign court or to arbitration. Now, the provisions of Article 248 could be used where there was a pre-existing arbitral agreement if that arbitration agreement had been rendered unenforceable due to the application of restrictive measures that would cause obstacles to access to justice for the Russian party. The travaux préparatoires, the explanatory documents related to these amendments explain that the purpose of this amendment was to provide legal protection to Russian legal entities and individuals which were the subject of foreign sanctions. However, the Russian courts have given an expansive interpretation of these provisions based on what the courts have seen as being the purpose of these provisions to protect Russian parties from the perceived effects of sanctions more generally. Really, starting with the Russian Supreme Court's decision of the 9th of December 2021 in the case of Transmash and PESA, a Polish company, the circumstances in which these provisions can be invoked by Russian parties has been massively increased. Now, there is no need to demonstrate that the Russian entity in question is specifically listed or targeted by a sanctions regime. According to the Court of Appeal in A1 Capital and Credit Suisse, it was sufficient for these purposes that sanctions underlie the dispute, and that the plaintiff, the Russian party, had simply expressed its will to resolve the dispute in the Russian court. Furthermore, there's no need to demonstrate that sanctions actually create obstacles in access to justice in order to render the arbitration agreement unenforceable. In the Ural Transmash case, the court at first instance had originally rejected the Russian party's position that the arbitration agreement was unenforceable because the Russian party had actively participated in the arbitration proceedings. But the Supreme Court in Russia said that under the correct interpretation of this rule, the application of restrictive measures itself, by definition, already creates access to justice issues on the basis that the Russian party had its reputation affected by the imposition of sanctions. Now, I'm conscious that I'm running out of time. The other aspect I would just highlight under Article 248 is the ability of Russian parties to obtain anti-suit injunctions with the intention of preventing foreign arbitrations from taking place. And a failure to comply with an anti-suit injunction results in a fine equal to the amount of the foreign arbitral proceedings, or the claim in the foreign arbitral proceedings. To take a recent example, the Uniper case and Gazprom, the value of the claim that Uniper had filed in arbitration was 14.3 billion, and that is the amount of the fine that the Russian courts have imposed against it for breaching the anti-suit injunction. Just very quickly, in terms of practical strategies for managing the risks that are posed by sanctions in the context of arbitration, I think prior planning of your arbitration agreement is vital in order to mitigate the effects of sanctions on the mechanism of the arbitral process. So selecting a seat and an institution in a so-called neutral jurisdiction will avoid payment issues, and it might also avoid allegations of bias or procedural irregularity in the proceedings. Selecting a neutral venue for hearings will also avoid the issues that I've identified with travel to hearings. And what about the risks of countermeasures? The Russian Article 248 issue. Well, first of all, I'd suggest anti-suit injunctions at the seat of the arbitration, forcing the Russian party to withdraw its proceedings in the Russian courts. However, they are of limited effect. Russian courts do not recognize the effect of foreign anti-suit measures. And so you are really reliant on the willingness of the Russian party to voluntarily comply with the anti-suit injunction in those circumstances. They may do so if they have assets in the jurisdiction where the injunction has been given, but more often than not, the Russian party won't have assets there, and so it's very difficult to force compliance. The other option would be to commence arbitration proceedings first. As I mentioned previously, Article 248 is only available if there are no pre-existing court or arbitration proceedings taking place elsewhere. However, if a Russian court determines that the arbitration agreement is unenforceable, then it's likely to ignore the fact that proceedings have been commenced in accordance with the arbitration agreement and will presumably proceed to take jurisdiction over the dispute. And of course, Article 248 is only really of use to the Russian party if there are assets within the jurisdiction of the Russian courts against which it can enforce a decision of the Russian courts. And so if it is the case that a client has assets located in Russia, then it might be advisable to try and relocate those assets where possible. However, I do appreciate that the restrictions on the repatriation of foreign-held assets from Russia is difficult given the restrictions placed on movements of capital and assets out of Russia. So in very brief summary, as I'm conscious of the time, sanctions can have various unforeseen effects on arbitral proceedings, and the rapidly changing sanctions landscape means that lawyers and advisors need to keep up to date with the current situation so that they can ensure that both they and their clients are compliant. More fundamentally, sanctions are being used as a means of undermining arbitration as the leading method of international dispute resolution. Russia has effectively stepped outside the global legal order in many ways, including in its treatment of arbitration. And I would say that it's difficult to predict whether or not other countries who may be faced in the future with sanctions imposed by the international community may take the same approach in terms of ignoring arbitration agreements and allowing their local courts to take jurisdiction over international disputes. I'm out of time. I'd just like to say thank you very much indeed for your attention, and I will be around if there are any questions at the end.
Thank you, Mile. Many thanks. Overview of the influence of sanctions regimes on the arbitration procedure. First of all, and it was really have great pleasure to have you here today. And would you like to stay with us until the end in case of some questions from our audience? Michael?
I will repeat that because it is in English. Would you like to stay with the session till the end of it? Thank you.
Друзі, ми рухаємось далі.
So, dear friends, we are moving forward. Our next speaker is Maria Kostitska. We announced her presentation, so she is going to be with us online. And so, Maria, please. It's great to see you. Can you hear us? Okay. So maybe we cannot hear you so far. And not so far, okay. So please check the connection with Maria. So we can hear you. So can you hear us? Can you see us? Yeah, just a minute. Yeah, we can hear you okay. So Maria, the floor is yours due to the fact that we're a bit late, but please try to stick to the timeline. So thank you very much, Volodymyr. Thank you very much, Mykola, for this opportunity to present at this event with my colleagues. And my colleagues already covered the impact of sanctions over Russian Federation and impact of the Russian Federation on the international proceedings. Within my presentation, I will focus on implementation or enforcement of arbitral awards and court judgments on the face of challenges. Can you see the slides on the screen? No? Oh, yeah. So now we have it. Okay, before starting analyzing the enforcement mechanism under these challenges, I will give you some statistics on the judgments already taken, starting from 2014, from occupation of Crimea and some territories in Donetsk and Lugansk Oblast. Ukrainian companies and businesses started 12 arbitration cases against Russian Federation, and so these 12 criminal proceedings were initiated. 4 were initiated by state-owned enterprises, 6 were initiated by the companies by Igor Kolomoisky. So it's Private Bank, Ukernafta, Stable, Everest Estate, Airport, Belbek. And 2 cases were launched by Rinat Akhmetov and his companies, Rinat Akhmetov Investor on DTEC. In 10 cases, arbitration cases recognized their jurisdiction, the tribunal's jurisdiction, despite the ambiguity that existed in 2015 and as regards the occupied territories in Crimea and Donetsk, Lugansk Oblast, and the time when the investments that were made, and the time that, and in 9 cases, the tribunals recognized the responsibility of the Russian Federation per merits. In 7 cases, the arbitration tribunals already gave arbitral awards to the tune of $7 billion to be provided to the Ukrainian companies. 5 cases, the proceedings are still pending. One is still on merits for Ukrenergo, and 2 other cases. In 7 cases, Russian Federation did not participate at the beginning, just sent a letter from the Ministry of Justice of Russian Federation that it doesn't recognize the competence of the arbitration tribunal, and the Russian Federation appeared at the moment when the arbitration cases were cancelled in Sweden, Netherlands, France, and so on. And in 2 cases, the cases were cancelled in Switzerland, in 2 cases Netherlands, and 1 in France. In Switzerland and France, the attempts to cancel these cases didn't succeed, and the national courts didn't go beyond these limitations. In France, when Oshad Bank sued the Russian Federation, then the Russian Federation took into account new evidence, and so they applied. They used more in-depth control, and the document was filed also by Russian Federation that the branch in Crimea was established before 2014, and so the investment agreement is applied, can be applied only after some period. So, according to the argument of Russian Federation, arbitration court didn't have the ratio temporis. So therefore, there were very complicated proceedings in the appellation court of Paris and then in the court of France, whether it is under jurisdiction or whether it is the subject matter of per merit case. In 2021, the appellation court of Paris cancelled the decision of the arbitration case, which was in favor for Ashad Bank, and then both cases were transferred for the new trial, and now these 2 cases are still pending in Paris. This is regarding the judgments which are related to the war which started in 2013. Starting from the largest scale invasion in 2022, one investment case was launched, Rinat Akhmetov against Russian Federation, related to the destruction, seizure, and loss of assets in the eastern territories of Ukraine, including the Azovstal plant in Mariupol and Donbass Arena Stadium in Donetsk. And it's known that a notification was submitted on arbitration tribunal. Then Ukrhydroenergo filed a case 6 months ago related to the destruction of Kakhovka plant. And also we have news of a group of unidentified investors also sued against Russian Federation and arbitration case. Now let's switch to the court judgments, because the disputes with Russian federations they are not limited by international arbitration courts. The absolutely emblematic resolution of the Supreme Court of Ukraine as of the 14th of April 2022 led to the precedent for denial of jurisdictional immunity to the Russian Federation, despite that there is the law of Ukraine on jurisdictional immunities. And the case, which is now known to the international community and Ukrainian community, and there is a case when a wife sued against Russian Federation that her husband was killed as a result of Russian aggression, and the lawsuit was justified by the damage or moral damage by the loss of the family member. And according to the norms of the positive law, the Russian Federation could be can be a defendant in this case only in case of immunity. And when there was a cassation tribunal, then the appellation decision was cancelled, and after the start of the war in Ukraine 2013, then the Ukrainian court has the right to consider the cases against the Russian Federation and do not take into account the immunity of Russian Federation as related to the armed aggression of the Russian Federation. And using this precedent and this emblematic resolution of the Supreme Court on cancellation of the immunity of Russian Federation, around 300 Ukrainian physical and legal entities sued against Russian Federation about compensating the damage. And I'm giving you the numbers, how many numbers against Russian Federations already being considered, and not to waste the time, I will tell you about the enforcement of the cases in Ukrainian or international jurisdiction, because the critical issue is about the enforcement and what assets could be used in order to enforce these decisions. And I would like to draw your attention to the case of Everest State versus RF against RF. That's the case is related to occupation of Crimea. The Ukrainian claimants they wanted to put the forfeiting on the Prominvest Bank, which shares were owned by Russian Web Bank, and Ukrainian claimants wanted to get the result as a confiscation of these shares. And the court applied this doctrine on person corporate will or alter ego, and the court stated that the Ukrainian claimants can use the web assets in order to because the web has bank is controlled by the government of Russia, and this is the company which is used to achieve government's purposes. As these criteria were met in this case, therefore, the forfeiting measures could be applied to the property of a web bank. Now let's get to other countries, because other countries also has a general principle on in order to so you can use the assets alter ego, because in Ukraine there are no more Russian assets that can be forfeited or confiscated in order to perform the enforcement of the arbitration cases. Let's see at the issue of the immunity issue. As regards immunity, we are going to talk about the advantages of the arbitration decisions in implementation against Russian Federation. In order to enforce the arbitration decisions of the international jurisdictions, they must be converted into the national courts judgments of international jurisdiction, and when this decision is converted, then you can use the full scale of enforcement measures. It's about the disclosure or forfeiting. So we have to approach the jurisdiction that has these Russian assets or alter ego or related enterprises where the money flows go, and where you can get the information on the use of these actions. As arbitration decisions at the international jurisdictions have some advantages versus court judgments, because arbitrations judgments have some simplified procedures, at least in theory, which are described in New York or Washington conventions. And arbitration judgments has exceptions on immunity of some countries. And in terms of this simplified procedure on relationships between Ukrainian and Russian parties, the New York Convention is used, which includes a list of justifications where this arbitration court judgment can be enforced. And if there is a wrong decision on merits, is still not the foundation for for cancellation of the whole judgment. And as regards the second advantage, as you see in the screen, it's the arbitration exception is reflected in many countries. Now you may see the arbitration exception of the United States, and the next slide you may see the arbitration exception of the UK on the immunity. In both cases, when we discuss the recognition of arbitration decision, then the country debtor doesn't have an immunity. And in France, when there are no positive norms on immunity, so there is no law per se, the case law is applied, which utilizes the common law, UN Convention on jurisdiction, and the same laws are reflected in French doctrine. and the recognition of Ukrainian judgments is more complicated, but it is possible. As for so the it is related to the use of jurisdiction, whether the national legislation is used. And here I will share very good news on that the European Union, despite all the pessimism, skepticism, in August this year, the Hague Court stated that the judgment by the court of Zaporizhzhia Oblast can be recognized, and the Hague Convention could be used because it and the responsible convention came into force in 2023, and there are important points to be discussed here. The Hague Court came to the conclusion that the Hague Convention has to be applied ratione temporis, irrespective of the fact that it had been adopted before the convention was adopted, and it is important. So the procedure of application started afterwards, and it is gives some hopes for the Ukrainian applicants, so you can use this convention even if you had applied before. And the second inspiring moment is that the Hague Court stated that the case of war doesn't preclude from application of this convention, because the expropriation of the property in Crimea occurred not as a result of armed conflict, but as a result of administrative actions of the Crimea administration. And in this case, the immunity of Russian Federation was not an obstacle in order to recognize the judgment of the Zaporizhzhia Oblast Court, and this decision was adjudicated against alter ego of Russian Federation. So these are two new events in European Union, and outside EU, the Hague Convention is not applied, but still Ukrainian court judgments can be recognized and implemented. For instance, in the United States, the typical law is used on recognizing international courts and money judge recognition acts, and it is applied by different states. And as regards the foundations for recognition, non-recognition, they are not related to the merits, they're just related to the violations of the procedural procedures and so on. In UK, recognition of Ukrainian courts is implemented in compliance with the common law, and then Ukrainian court's judgment can be considered to be debt, and then can be a simplified procedure, summary judgment procedure in the UK, and the preconditions to refuse considering the case cannot be related to the merit. They may be related only to the violations of the procedures or in violation of the national justice. So they are not related to the case essence or per merit. And about the jurisdictional immunity, very quickly. So in compliance with the general law, the Russian Federation has the immunity. It is very difficult to override, but still there are precedents how to do it. Let's start from the US. Our 2-year research has not revealed any exceptions on immunity, because in compliance with the FSA, exploitation or delict exception they or tort exception, they are not used. But it's still, there are attempts. Last month, another attempt was undertaken in California courts. There was an attempt to recognize the commercial court of Zaporizhia Oblast on the appreciation of chemical plant in Luhansk Oblast, and this case is still pending. In UK, our research identified some disparagements in the use of this legislation, but still we do not have information on any cases launched. While recapitulating so we have a critical issue. What sorts of issues, what sort of assets can be used in order to satisfy the demands against Russian Federation? And we have to divide the assets related to Russian Federation and belonging to alter ego Russian Federation, and also the assets of those who are sanctioned and those assets which are frozen or confiscated. So in the majority of Western states, in addition to the Russian Federation's immunity, there is also immunity of the sovereign property, which is protected from forfeiting, but still there are exceptions if the assets are used for commercial purposes. In this case, forfeiture can be applied in order to enforce the arbitration cases. In some jurisdictions, you can use the assets of the alter ego state, not the state itself. So even if these enterprises have their own property and they are not relevant for the state, I will give you the precedent from the US to give you the criteria so that the US courts can adjudicate that you can use the assets of foreign states' alter egos. And let's proceed further on frozen assets of the Central Bank of Russian Federation. That's 300 billions, which are and they already they have interest rates in favor of Ukraine, and mostly these interest rates will be used to purchase weapons, support critical infrastructure, to support loans to be provided by the Western Europe and US, and also to compensate for the certain categories of losses through the centralized compensation mechanism, which was already mentioned today. In addition to the special immunity of central banks, as regards the use of the principles, there are some subtle nuances, because there are sovereign bonds issued by Western countries' partners, and which are held by Russian Federation as a bondholder. Therefore, there are some aspects, additional aspects here. So, but we may think that the amount of this cost can be used for compensation mechanism, and if Ukrainian creditors want to have their losses compensated not through the central compensation mechanism, so we shouldn't forget about other Russian assets and alter ego assets which have not been frozen so far, and we shouldn't forget about the sanctions regulations of the international of other countries, which allows a use of the frozen assets in for enforcement of arbitration courts within the certain timelines, provided that there are specific mechanisms for that. It is a broad issue, but concluding, if we want to navigate in these uncharted waters of court judgments, it's already at the start of the arbitration complaint. You have to identify the assets which could be either arrested or or frozen, and only if you identify these assets, then you can invest into further arbitration proceedings. Thank you very much for your attention. Maria, thank you. It was extremely broad and clear and concise presentation on various aspects of impact from the perspective of enforcement and confiscation of assets. Thank you, Maria. Can you stay with us for some time if there are any questions from the audience? And then like 10-15 minutes. Thank you. Thank you. And now I'm giving the floor to Olga Kosteshina, who will tell us about the specific of the arbitration disputes of martial law. Thank you very much for those who still stayed. So I will not keep you for long, and will not stay between you and informal networking. So we have a very like home atmosphere already here. We're going move forward. The topic is very interesting and broad. Well, frankly speaking, we're going to finish on a positive note, but when formulating this topic, it is sad to pronounce, because I don't know about any arbitration institution which survived both COVID, but the arbitration institutions which fully perform its functions under war conditions. It's the unique experience of Ukraine. I think the International Commerce Arbitration Court wouldn't like to have this experience, but it's our reality, and that's what we can share. This year I attended many conferences in Europe, and I would like to say that well, having this set topic, we are talking about some positive issues in order to bring some positive things here, some positive issues. And here is the statistics of the International Commercial Arbitration Court. Of course, these are the consequences of the economic crisis, but still the number of the personnel of International Commercial Arbitration Court is just 10 people. They effectively administered 584 cases in 2023. This is much higher number than those which were registered with the European and international institutions like ICC. Of course, it cannot be compatible with ICC because it's so. To give you an example, ICAC it can be compared to VIACA, and they registered just 54 cases. And these 54 cases, they included both not only international cases, but also local cases. So it's like 10 times less. And our personnel informed me that as of 6th of September 2024, we have 363 cases registered at the court. And since 2022, our court started to identify the special cases related to defense industry. Earlier, there were very few cases. Like in 2022, there were only 9 cases, and that was 2.4% of all the cases. In 2023, we registered 41 cases for defense industry. And now this number of these cases is increasing. Naturally, these cases were considered from the perspective of the import of the military products, and if you analyze most of these contracts, you may identify two key aspects when the arbitration court works. International Commercial Arbitration Court and Vienna International Arbitral Center work. And although we in 2022, 2023, Vienna International Arbitral Center states that Ukraine is ranked 4th at the top 5 rating of those who who submit files to the Vienna International Arbitral Center. For instance, 2022, 6 new cases were registered there, and we don't have the disaggregation, but we are 3rd now. So today, earlier we discussed agricultural arbitration, investment arbitrations, or energy arbitrations. Now we have to identify specializations on military goods arbitration, because we understand that till the war is over, the number of such cases will increase. And this is a new specialization. That about the arbitration institution, that's great to make this presentation after judges, because the new case law was created, and I took several cases which cover the most important aspects, because the parties against which the arbitral decisions were made, because some of the companies tried to take advantage of this war time, and in order to cancel the cases of the judgments of the International Commercial Arbitration Court. And you may see the key tendencies in this case of so the concept of public order was reconsidered in Ukraine as related to the law on sanctions. And the previous speaker mentioned the decree 187 of the Cabinet of Ministers, and both parties tried to take advantage of this decree, saying that we now have a moratorium to pay in compliance with these arbitration judgments, and this court stated that the ban for payments, that doesn't mean that the judgment is cancelled, because there are clear provisions in the procedural code of Ukraine, and it is not all. In some cases, well, historically, Ukraine and Russia had tight economic connections, and there were quite a lot of disputes when the goods were produced by Russian Federation enterprises, although the owner could be somewhere in Europe. And then the structure received the negative judgment. The justification was about the funding from the aggressor state. So here the courts looked in depth the judgments of the International Commercial Arbitration Court. Here the case was considered in 2022, although the equipment was delivered in 2020, and therefore the court decided that this law is not within the jurisdiction of the decree of 187 about the currency restrictions. So There were attempts also to not to implement the decision of the arbitration court due to this decree of the National Bank of Ukraine, because and so these relationships, which the actual delivery was conducted in 2020, and therefore the National Banks of Ukraine didn't work. And one more very interesting case when the local court about the online session and air raid alert. Now foreigners are listening to us. During COVID times, most of the cases were considered online because not everybody was in the position to come to Ukraine. And in this very case, when the case was considered, and one person was in the premises of the arbitration court, another was online, and we had an air alert, and the pause was announced. And then when the session resumed, then the online participant didn't take part, and the case was considered, and the party considered, which was in line, that its rights were violated, and the decision, and he wanted to cancel this decision, and the appellation court took into consideration, and the court announced that there were no obstacles for the online party to join, because at the same time, when the hearings were ongoing, the trial was ongoing, and these parties sent emails. Therefore, that means the interconnection was in place. So it was there was several judgments of the this arbitration court. So there was a case law of the military time. So I would like to speak about the future. I call this slide "New Era of Arbitration" or development. And Serhiy Grishko already said today that Ukraine cannot be higher than Czech Republic. Well, it can. It can be higher like anywhere. We have one of the best practices, arbitration practices, and for instance, there are decisions in Poland and Latvia adopted the law on reform international arbitration just now, and we did it in 2017. So there are a lot of things that we can be proud of, and the Ukrainian arbitration courts opened a new page in the development of these new practices, because European Court of Human Rights also shifted this platform to the arbitration sphere, and there have been no cases so far. I think we're going to have new cycle of arbitration cases against Russian Federation related to the damage and losses inflicted by Russian Federation, and about new cases to appear. And I would like to mention the new generation of disputes in the energy sphere, because now we have like the fourth or the fifth cycle of energy disputes with the closures of nuclear plants. And I think the next cycle or round of these cases will be related to the destruction of energy infrastructure of Ukraine. And of course, it is important to convince Ukrainian businesses to filed their lawsuits to courts, including to arbitration courts, and many court restrictions were mentioned. Since 2022, International Commercial Arbitration Court received at least dozen of Russian judgments with the demand to stop arbitration proceedings against Russian enterprises. Naturally, they were ignored. The cases were still considered. Some of these judgments are recognized, some are pending, and as I, for those who are interested, at present, and you heard about the UK courts, about Switzerland courts. Now there is a new case law at these courts as related to the armed aggression, as related to the Russian refusal. We mentioned the case of Deutsche Bank, and we also mentioned Commerzbank against Roschem Alliance. As we discuss sanctions, there are a lot of cases initiated as related to the sanctions applied after the invasion of the Russian Federation against Ukraine, both in US, UK, and in Ukraine, and some investment cases already occurred, like ABH holding against Ukraine when Alpha Bank was nationalized. I would like to make a comment here that the country could adopt the legal regulations within its territory which consider fit, but if an arbitration agreement is regulated by international intergovernmental agreement, then the arbitration will consider it holistically and not take into account like less sovereign immunity. Beneficiaries of Alpha Group filed one more arbitration against Luxembourg. On the 16th of August, Alpha Bank beneficiaries filed against Ukraine another lawsuit. And the tribunal is being formed, and I would like to discuss some issues with Michael, because services. So UK firms often provide services to these Russian oligarchs, and we may witness that recently Russian oligarchs could initiate some cases in Exida, so they don't have problems with paying arbitration costs for Exida. So they don't have problems with that. So
we feel no pity for the Russians. Beside that, what I would like to emphasize that coming back to the question of sanctions, in the beginning of 2022, 6 arbitration institutes have joined and wrote the open letter with the objective for the access to the legal services. It was possible to pay for the lawyers, the fees, and ICAC on the 2nd of September they were the amendments to the decree of the National Bank of Ukraine number 18, and there was an initiative to remove the restriction, the currency limitations for the ICIC cases, and at the same time, with the International Arbitration Court, the decisions were made, and no obstacle for the Russians. If they wanted to participate in these cases, these proceedings, there are no obstacles for them. And beside that, the Russians, they are trying to respond somehow. We consider that our sanctions are countermeasures, and the Russians are considering our countermeasures that they require the countermeasures, and in this way there are new type of cases. For example, against the assets of the Uniper company, which is serving a few energy objects on the territory of the Russian Federation, where the temporary administration was established, that it's a German company, or against a Finnish company, Forto, which was serving a few energy objects on the territory of the Russian Federation, and these assets were forfeited to the Russian Federation. And therefore, while Europeans are still discussing ACME case and the issues speaking of the energy disputes, I would like to say that Ukraine, I'm talking not only arbitration, is not only the source of arbitration practice, but the source of the new practice of commercial and, first of all, investment arbitration. And after it was adopted, everyone started to quote the Crimean arbitration. I'm quite confident. I do not know how they are going to be called, but the new investment arbitrages, which will be dedicated to the reimbursement for reimbursement. I think that they are going to have a very big impact, which is difficult to foresee at the moment to forecast. So I wish to prevail in this war and to stay alive till victory. Thank you, Ms. Inna. Thank you for a positive perspective note that Ukrainian practice was going to affect the international one. Thank you very much. And dear colleagues, dear participants, as we've listened to all of our speakers, and at the moment we have Q&A session, and we understand that it's 10 to 7, so maybe one or two questions if you have. No, Friday evening, 10 to 7. We do understand everything? Yes, of course. If we have Mr. Michael with us, is he with us? Yes. So, Mr. Michael, can you hear us?
Yes, I can.
Okay.
So you were explaining us quite interesting about the restrictions regarding and the difficulties for the Russian subjects to pay for the expenditures, arbitration expenditures, including the payments to the lawyers. And at the same time, you were saying that the Russian subjects are trying to use alternative ways of payment or to use the services of the financial institutions of the third countries. And therefore, I have the question. Do you considering the fact that the EU and most of the partners have imposed the sanctions, which make these operations more difficult, the usage of these alternative means to the way of overcoming the sanctions, and there is a punishment for them. So in some of the EU countries, there is responsibility for avoiding sanctions. It is implemented in the UK, and the US are proudly using this punishment. Do you consider these kind of payments the way to avoid the sanctions? Thank you.
Thank you very much, Deputy Minister, for the question. I think I'd start by saying that the payments that I was referring to are the payments that are legitimately made by Russian entities who are engaging lawyers in respect of cases before courts or before tribunals, because that is a right that is protected by the European Charter on Human Rights. And I think equally the same rationale applies in the UK in terms of permitting payments from designated persons to lawyers for the purposes of certain legal services. I think the issue that I was describing was more to do with the difficulty that Russian parties have in making those payments from Russia to the arbitral institution, the legitimate payments that they are permitted to make for the purposes of obtaining legal services, and by that I would include payments to arbitral institutions for the advances on costs, because of the difficulties of Russian banks accessing the international banking system. So for those purposes, I think that the payments themselves are probably legitimate. The difficulty is getting those payments out of Russia to the lawyers or to the arbitral institutions, because I think it's right that sanctions do permit these payments to be made, because the provision of legal services in respect of contentious proceedings is a recognised right, irrespective of the existence of sanctions. In terms of routing those payments around the banking difficulties that Russian parties face, I think that it would be very difficult for the EU or the UK to take any steps, or even America for that example, for that matter, to take any steps to prevent those payments if, for example, they're being made from Russia to a Chinese bank or a Hong Kong bank, and then being paid on to a bank account in the EU or the UK. So for those purposes, I think it would be difficult to regulate that from a sanctions perspective. But equally so, I don't think we would want to, because it's right that Russian parties have the ability to either bring claims or defend themselves in a commercial setting. But this is also an issue of justice for the non-Russian party as well. If you are a European operator and you have a claim against a Russian party that you need to bring in arbitration, it's a very expensive thing to do. And so you want to be able to force your Russian counterparty to contribute towards the costs of those proceedings. And so you need your Russian party to be able to make that payment via Shanghai or Hong Kong or Singapore, wherever it might be, in order to allow those arbitration proceedings to take place. Because if not, there is a risk that justice will not be done in that case on behalf of the non-Russian party, and claims will go stale, or they'll become time barred if we wait until sanctions regimes ease following the end of the war.
Thank you. I have some certain concern, and I would like to say that, in fact, in Ukraine, we feel it more natural that the Russian Federation and most of the subject of the Russian Federation, they are trying to exploit this right for their best interests. And if so far we consider the Russian Federation as a subject to the international law with preserving all of their rights and freedoms, in this case we are talking about the fact that the Russian Federation will continue to violate all of the principles of the international humanitarian law without any kind of discrimination in any of its rights. And therefore, today, the Russian Federation and the subjects of the Russian Federation, especially the sanctioned individuals through the claims to the arbitration courts, and today we mentioned only some of them, and we have lots of them, dozens of them, against different countries in the European Union, against Ukraine, and that is a cynic attempt to use the laws to protect your own best interests. And then the question to the international community, to the lawyers, of the highest level, whether it will be allowed for the Russian Federation and the subjects which support the Russian aggression in Ukraine who are sanctioned to use the rights and freedom for their interests, to protect, to defend their interests. If these kind of scenarios are possible, and if these decisions will be made, in this case we can say that we will never avoid the war conflicts, because any kind of subject which is fault of this aggression has no obligations and will face no discrimination and punishment. And as for the access to the justice, I totally agree with you. And as the representative of the Ministry of Justice, I will always insist on the fact that every side should have the proper access to the justice and the possibility to pay the arbitration fees and the legal expenditures. And at the same time, it should be happening through some licensing for both to have the control over the sanction limitations. If the Russian Federation or the Russian party wants to pay for the expenditure, they have to contact the relevant authorities of the country which impose sanctions for paying these kind of expenditures. So in my opinion, it is legally simple and logical way which can help to avoid the gray schemes and the alternative ways of paying for the services which are not under control. Michael, do you have any reflections on this?
This comment. Okay, thank you. Thank you, Michael. Thank you for a broad overview of your point in this respect. Пані Інна, так само дякуємо вам за запитання.
Ms. Ina, thank you very much for your question. Dear colleagues, any more questions? No. Okay, so let me thank our speakers and all of us who join our discussion. And indeed, we are very strong because it's Friday evening and we managed. So I'm passing the floor to Mykola Fedovich, Miss Maria, Michael. Also, thank you virtually. Thank you for joining us and thank you for your patience. So I would like to conclude, but after this kind of applause, I feel that I need to leave the stage because you will beat me after that. So this discussion, which was long, it was fruitful, even though we will make the conclusion that we have delayed the end of this conference for 2 hours. But for me, even though it was going to be financially expensive, but it was very important. So what conclusions did I make? First of all, there were wonderful words so that we have to improve the image of Ukraine. And moreover, everyone, especially during the first panel, were talking about that. And we shall move forward towards the international arbitration only in the case when we join our efforts, arbitrage business and cultural community, together with the state official authorities. I think they've heard us, and that's very important for us. If we step by step start to move towards the objectives we were discussing, in this case we will achieve. That is the first thing and the main conclusion regarding today's discussion. Arbitrage will happen in Ukraine, and the other alternative ways of resolving the disputes will also take place in Ukraine. The only thing we need is to undertake a bit more efforts to be able to destroy these uncertainty of unclear information which we can hear about Ukraine, Ukrainian justice, Ukrainian legal system, and the rest of our features which are not truths. And now even the critical minds who criticize the court systems, if they at least somehow objective, they can say that the court system of Ukraine is probably takes one of the first places when it comes to the arbitration. Today we were discussing that if they are at least somehow objective and they are not absolutely subjective. So please, we have to we should not only just observe, but we should we also feel it in our reality, and it's more positive. And we were talking about the Chamber of Commerce of Ukraine, and let's not forget about alma mater, and I really like that it was mentioned. As speaking of the sanctions, it's really great that highly qualified speakers started to talk about sanctions and how to avoid them, how to avoid it, and what are the consequences for, first of all, the investment arbitrage for both the European Union, the US, and also for Ukraine. By the way, speaking of Ukraine, for us it is a huge problem for ICAC that the sanctions imposed by Ukraine on the arbitrage process and on the decisions which are made regarding the sanctioned party where when the Russian party is involved. And that is an important topic, and maybe that is going to be the topic for another roundtable, and we will invite you and we will have a serious discussion about it. And the other thing is that it's a pleasure for me that Ukrainian speakers, maybe I will say it a bit wrong, but I will try to say it very delicate, that they are on the same level with our international partners, colleagues. It says that Ukrainian elite is strong, that it's standing still on its legs, and it is all able to resolve different issues, not only arbitrage, but also legal issues, as well as their foreign colleagues too. So I hope I'm not wrong about it, and that's not only considering the experience of our arbitrage ratings, but also the participation of the legal companies, entities in the arbitration companies in ICAC. That is an incredible experience, that are very well educated and highly qualified and mostly very intelligent people. Therefore, on this point, I would like to end this conference. First of all, I would like to thank all of our participants of our conference for being strong, for being patient. And I would like to thank the moderators. And I'm very sorry that I didn't give you the floor, because there are some certain aspects, and I would like to thank all of our speakers who were extremely positive, extremely qualified in the topics so they were highlighting. And for me, in my opinion, it was extremely interesting to listen to all of them. And therefore, I would like to thank everyone who participated our conference. And I have to thank the Secretariat of ICSC for the support and organization of this event, especially my deputy who managed all the organizational work, Ms. Ina, on organization for the arbitration readings. It's not her fault that this program took a bit longer, but that's and I would like to thank the Chamber of Commerce of Ukraine, who undertook lots of efforts for our work to be comfortable. And thanks God, we didn't have to go to the bomb shelter, and that's really nice. And I would like to thank our centric hour, because he worked with ICSC for a long time, and they already the part of our team. You will not escape from us. And I would like to thank our interpreters. I'm very sorry for taking longer. We will compensate your efforts, and I would like to thank everyone who became the part of this conference. And the last thing, just from me, I would like, dear friends, to thank all of you for your participation, and because you and moderators and speakers, you supported the position of the national arbitration institutions of Ukraine, and that is really important. And we observed your support, and your support will fuel us in the future. Olga Kostishina said it really right, that we are working in very difficult conditions, and we are not saying that aloud, but the conditions we are working in are really difficult, and that the decision was cancelled due to a red alert. We actually worried because it was not fair, and thanks God it was, and thanks to court it was reconsidered. And that is another proof that the level of the court branch of power crew, and the Appeal Court of Ukraine and the Cassation Civil Court of Ukraine, which are in charge of our decision implementation and cancellation. So the level has really increased, and the level of the courts and the judges has increased. It's better than it was before the reform of procedural legislation. And I want all of you to remember that, and that actually is the reality. And even if I do not like any kind of decision, one of the heads of the court system said the judges are independent, and I cannot tell them what kind of decision they should make. But the practice will correct everything. And therefore, I would like to thank all of you once again, and those of you who are in line, who were watching us. I would like to thank those people who are in our audience, and now we shall have a cup of tea, and we will tea a bit, and we will discuss the problems, and I have something to talk to you about. And therefore, you see, as my former advisor, he's telling me what to do. So let's finalize our broadcasting, and we will we will see the justice in this world, and we will recover the economy of Ukraine. And the youth is our future, and we will see this future. So don't be pessimistic about it. Only positive in the future. Thank you, all of you, and have a peaceful sky over your homes, and goodbye.